Good morning. It's not such a bad day here. Sun is out. Looks like the sun is also out partially in Massachusetts, where we're headed for the Karen Reed trial again this morning. As we're waiting for court to start, the feeds are up. And, well, I was considering about yesterday's testimony. There is a lot to go over. And, well, if you read the socials, depending on which side you land on, if you've actually decided on a side, it was either good or bad. I actually think it was awesome. I think, well, I think Jessica Hyde was an excellent witness. She was informative, professional, an obvious expert in her field, well touted, um, whoops, extremely knowledgeable. But more than that, she had the ability to explain things in a way we could all understand, like a professor, which she is. Now, she literally laid it out that that supposed Google search did not happen at 2:27 a.m. Kind of dismantling the defense's claims there, which they keep sticking to. And although Robert Alessi was, well, let's just say boring, well, he did keep me awake because every once in a while he would yell a word like some disjointed TED talk or something, like scaring the heck out of me. Well, at least it kept my head off my desk, but he really didn't know the technology as well as he thought. Because one of the most amusing parts of the testimony was the expert herself correcting him, even in his question, telling him his question made no sense. When he would pick words from a artifact and she would say that's related to that artifact in like the whole answer is this, she wasn't letting him manipulate her. He did make his point about the Faraday bag. Well, she did come back and say, well, in cases where the victim is deceased, you may not put it in a Faraday bag because you kind of need them to unlock the phone. That kind of resonated. But here's where, as much as the defense tried to tear apart her testimony, because remember, we know, but the jury doesn't, that they really wanted to impeach her based on another trial, on testimony somewhere else that did not have the same kind of evidence. Well, it was forensic, digital forensic evidence, yes, but the same kind of situation with the Google search. But it wasn't. And it was about her mythology. And so that is why we heard a lot of the boring stuff about how she did this and how she did that. Because, the Commonwealth said, well, if you're going to go there, we're going to give the jury everything they need to know that it's not relevant, even though they weren't allowed to bring the case in. Hank Brennan doesn't trust them, and I don't blame them. He laid the foundation anyway. Well, the defense went hard, or at least as hard as they could, with the lack of knowledge and lack of anything to really pick apart. And with Robert Alessi, as good as he is, his droning on technique about things he didn't really know, and it was obvious he was nitpicking words here and there to try to stream something together, which some people on the socials thought was a gotcha. Maybe they forgot to hear her answer. Or maybe they forgot the part where he tried to throw out those 86 steps again to get the now deceased body of John O'Keefe that's laying in the snow into the house, 834 Fairview. But her answer was brilliant. He said, well, that means he could be moving. That means perhaps there was activity after the certain date. And she said, no, sir. That could be this, and this. Just as much. And then she said the big thing. The big thing that's always missing in the answers. She said, you'd need more than just the registration on the health app to prove that. You'd need context and outside things to prove it. Just because the health app moved like it was steps doesn't mean it was. Yeehaw! We had a witness say context. We had a witness point to the fact that that health app saying it doesn't mean anything without footprints in the snow, without an eyewitness that he was in the house, without someone seeing something. Or you need more. You need the phone actually having interactions. You need activity on the phone besides the health app just saying about those steps. You need a actual timeline to support it instead of 20 seconds, because apparently 20 seconds is all you need to get beat to death and dragged back out to the snow. Oh, we are here already. Look at this.
Awesome. Thank you.
Morning, all.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Cannone, Justice of the Superior Court, holding in Dedham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
The slow rain
Good morning,
down.
Counsel. Good morning, Ms. Reed.
Good morning, jurors. This is great. This may be the earliest we've got started, so I appreciate everybody being ready to go.
Oh my
I
goodness.
do have to ask you those questions. Was everyone able to follow?
The
my
jury's
instructions
there.
and refrain from discussing this case with
There's
anyone?
no sidebar.
Everyone said yes and nodded affirmatively. Were you also able to follow my instructions? and
Oh,
refrain from
happy
any
Thursday.
independent research and investigation into this case? Everyone said yes and nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left it? No. Everyone said no or should take it.
Thank you. Mr. Brennan, your next witness, please.
Thank you, Your Honor. Commonwealth calls Yuri Bukhenik.
Okay. It's on with more evidence then. I'm in shock, people. Buckle up. This is going to be a day like an upside down day, and I'm all for it. I'm all for it. How do you spell this?
Please, the clerk.
You solemnly swear the evidence of the court and jury in the case now and hearing to the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Good morning.
Good morning, Your Honor. Good morning, ladies and gentlemen.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury and spell your last name for the record?
My name is Yuri Bukhenik. My last name is spelled Bukhenik.
Mr. Bukhenik, where do you work?
I work for the Massachusetts State Police.
What is your role with the Massachusetts State Police?
I'm currently assigned as a sergeant with the Norfolk District Attorney's Office in the homicide section.
I want you to take us back before you became a state police trooper with the Norfolk County District Attorney's Office. Where were you born?
I was born in Lviv, Ukraine.
Did you immigrate?
Yes.
How old were you when you immigrated?
I was 9 years old when my family moved to the Boston area.
Did you attend public schools?
Yes.
Through high school?
Yes.
Tell us what you did after high school.
After high school, I enlisted in the United States Marine Corps.
Why'd you enlist in the Marine Corps?
It was right after 9/11, and my friends and I.
Did they object?
Go ahead.
My friends and I decided to serve in the nation's armed forces.
Did you serve in the Marine Corps?
I did.
Did you go through training?
I did.
Did you learn any skills?
My specialty was military police, and I attended the military police school at Fort Leonard Wood, Missouri.
Through your military service, did you receive top secret clearances?
Yes, my first duty station was with Marine One Presidential Helicopter Squadron. The duty station requires a top secret Yankee White SCI clearance. And as a result, I attained that clearance and held it throughout my career.
Did you engage in any special assignments?
The Presidential Helicopter Squadron is a special assignment. We provide security for the presidential helicopters and presidential assets. With that clearance, we read into a SCI program, which is a need-to-know basis type situation.
How long were you in the military for?
4 years.
When you discharged from the Marines? What year?
2006.
Honorably discharged?
Yes.
After you were honorably discharged from the Marines, what did you do next?
I had a passion for law enforcement, and I wanted to serve my community here in Massachusetts. So I left California and came home and applied for various police departments, ultimately getting a job with the VA Hospital Police here in the Boston region.
When did you transition from the VA to the Massachusetts State Police? What year?
I actually transitioned to the Attleboro Police Department. I worked there as a patrol officer, SWAT team member, and then in 2011, I transitioned from Attleboro to Massachusetts State Police.
When did you join the homicide unit?
It was May of 2015.
And have you been in that position since?
I have.
And you're now a sergeant in that?
I am.
I want to ask you about the structure of the homicide unit for the state police. How many different troopers work in the homicide unit at Norfolk County DA's office?
We have a range from 2 to 6 troopers working in the homicide section over the years that I've been there. Currently, we have 6 homicide detective troopers in the section.
What type of cases does your unit investigate?
Our unit investigates primarily unattended deaths. Unattended deaths are those that are not attended by a physician. A variety of deaths, including natural deaths of old age, medical conditions, accidental industrial accidents, obviously homicides, overdoses. We have suicides as well. And those vary in age on the victims that pass, whether they're stillborn infant deaths, children that pass away of SIDS, or unfortunately teenage suicides.
Have you been to a number of scenes, a number of cases?
Yes, I have.
Do you handle more than one case at a time?
Yes, we do.
When a case, an unintended death is notified to your office, is that routine or is it by statute?
The notification comes in due to the statute requirement. In Massachusetts, under Mass General Law, Chapter 38, Section 4, the authority is given to the district attorney in each county to investigate those deaths. They appoint designees, and within Norfolk County, those designees are law enforcement agents from the Massachusetts State Police. So in our county, the Massachusetts State Police, with the district attorney's authority, investigate all unattended deaths.
You mentioned that it's called the homicide unit. Are many of the deaths that you investigate not homicides?
Primarily, the death investigations are not homicides.
When you walk into a call, do you have a preconceived notion whether it's a homicide or not a homicide?
When we walk into a call, we take in all the evidence, so we do not know exactly what we're going to have as a finding. We follow the evidence, we follow the information that we're provided, that we learn throughout the investigation. At times, it's obvious there was a homicide when the local agency that's reporting the death says that there was a shooting reported and there's a deceased person at the scene. So yes, we will know that it's most likely a homicide, but we don't make a preconceived notion or determination before we get there.
You said there are a number of cases that go through your office. Do you work investigations by yourself?
Never, no.
Are investigations assigned to the group as a whole, or is a particular trooper in the unit?
We have case officers, and the assignment of the responsibility when you will most likely be a case officer is scheduled a month or so in advance. So each trooper has a responsibility of a 24-hour period that they are on call. They respond to the scenes, whether it be a train strike versus pedestrian, or a vehicle, or a suicide by hanging. They respond, and then if they need assistance or they think that there's something more, additional resources are called out, like crime scene services, which helps us document scenes, etc.
Have you ever been assigned a homicide or a homicide investigation?
Yes.
In the cases where you're assigned, do you investigate the case alone?
Never. It's always a team effort. Every case requires a team effort. Just the amount of work that goes into collecting evidence, interviewing witnesses, interviewing involved parties, interviewing the suspect, all those tasks that are required in collecting surveillance footage require manpower and time and resources. And so every investigation, although it has a case officer, it requires a team effort of individuals to work together in concert to accomplish a successful investigation.
Are you often working on more than one investigation at the same time?
Yes, we are.
If you were the case officer, would you have other resources you would use to help with the investigation, other units in the Massachusetts State Police or local police?
Yes, typically we partner up with the local police detectives. And when we're conducting interviews, it's a state trooper and a local detective that are conducting those interviews or collecting surveillance footage and so forth. And there's a reason behind that. The reason why we pair up is not just the manpower, it's also that we work in a dangerous line of work, and people could lose their life, people could get injured, or unfortunately people could get fired or retire and no longer be available to testify, provide their testimony, or be a resource in the future.
Is it a common practice that when there is an investigation, more than one trooper will appear at many events?
It is very common and preferred. Unfortunately, in the real world, it's not always possible. A trooper can be responding to a scene and just to simply grab something from another trooper, and could be approached, and a small brief interview could happen. Or if a trooper's at a home talking to a witness and others show up and willing to provide information, he has to conduct that interview by himself because of the resources aren't available for him.
Let's talk about the assignment of this case. You said that there's case assignments, a schedule that is made in advance.
Yes, sir.
On the day or the morning of January 29, 2022, do you know who was assigned to take calls for new cases?
Yes, before 7 a.m. on the 29th, it was Michael Proctor that was assigned to be on call.
Is there a supervisor assigned as well, in addition to a trooper that's not in a superior position?
Yes, every day there's a supervisor assigned in addition to the on-call trooper. There's a supervisor that's also available for any reason at any time to respond, assist that trooper if there's any questions or issues that come up.
Was there a supervisor assigned that morning?
Yes, there was.
And who was that?
It was myself.
When did you first hear or learn anything about this call or this case?
In a unique fashion, this call actually came from the Troop H headquarters, which is the field services portion of the state police, the uniform patrols that service the Metro Boston area. The headquarters duty office contacted me, I think by mistake, misdialing the number because our names and numbers were listed one above the other. So the call actually came into me. I took the call and advised them that I would call the on-call trooper for that day, and they would contact Canton PD and take the appropriate steps.
About what time did you receive a call that morning?
Approximately 6:44 in the morning.
After receiving the call around 6:44 that morning, did you contact anybody to assign a case manager, or did you get involved personally?
I called Michael Proctor and told him to reach out to Canton and follow up on the report of a male in a snowbank.
And this is around 6:44 a.m.?
Yes, sir.
What did you do next?
I waited for a call back from Michael Proctor, and he reported the details of, yes, there was a male found in the snowbank in Canton, and that they were requesting our assistance as he had sustained injury and was unresponsive and had been transported to Good Samaritan Hospital.
What was the plan at this point?
At this point, where I learned that he had sustained injury and there was a heavy blizzard in the area, I decided myself to get dressed, shovel out, and respond to Canton.
Were you required to get involved and go to Canton that morning?
At this point in time, I was not, but I thought that it would be prudent on me to, at the very least, shovel out, because another call could have come in and I would have had to respond to that, and the driver would have been shoveled.
Were you in touch with Mr. Proctor?
I was.
Did you have any plan to meet him?
Yes.
When and where?
We decided to meet at the Canton Police Department.
And about what time were you going to leave your home, or did you leave your home?
I left my home probably around 8:50, and I know I arrived to the Canton Police Department approximately 9:15 in the morning.
Did you know the address where the person was found in the snow?
At that time, I learned the address once we got to the police department, but it had no significance for me. I did not know where it was.
Why did you plan to go to the Canton Police Department instead of going to the scene first?
The Canton Police Department, fire department personnel, and paramedics had already cleared the location. So we, again, given the conditions, we were in a controlled environment inside a police station to exchange information, collect any evidence if it was available, and the police department safety and security of that would have been the best location for it.
You mentioned that you arrived at the Canton Police Department around 9:15 a.m.
Yes, sir.
Was Mr. Proctor there when you arrived?
Mr. Proctor was there walking in with me.
When you went in with Mr. Proctor that morning, who did you meet?
We went in, we met with multiple Canton police personnel, one of which being Sergeant Good. He was one of the first responders to the initial scene.
Did you receive any items from Sergeant Good or any of the police officers while you were there?
Yes, we didn't receive it, but we were shown a broken cocktail glass, bottom of a broken cocktail glass. We were provided Mr. John O'Keefe's cell phone, and I was also shown a brown paper bag with 6 plastic Solo cups in it, containing what was reported to be blood in the snow.
When you were shown these items and had a discussion with the Canton Police Department, were any decisions made about the future of the investigation? You had shared with us earlier that typically the state police pair up with local detectives. Did you do that morning?
That morning, we did not. We had learned that there was a loose familial connection through town channels with the address and possibility of a Canton police officer or detective. So Canton police, out of overwhelming precaution of impropriety, not that there was one, decided to step away from any interview investigation assistance with us.
Has that happened in your career before?
Yes, it has. Yes.
Since there would be no local detective, did that change your role at this point in the case, your involvement?
It did not change my involvement, but it did bring up a concern of manpower. We are obviously limited by staff. The weather conditions also further exacerbated that issue. So transportation was an issue. Timing is always an issue, and you can never have enough manpower.
Did your role become more prominent given there was no local detective involved?
I would have to pick up the slack. I'm a team player. I always want to assist in any which way I can to make others' life easier.
And you were Mr. Proctor's supervisor?
I was.
After you received the broken glass, the cell phone, and you saw the plastic cups with the blood in them, where did the evidence next lead you?
Based on the information we had learned and the evidence, we decided that we needed to speak to the individuals who were last in contact and present at the scene when Mr. O'Keefe was found.
Did you have any specific other information that you were following at that point?
Yes, we had statements made by the defendant that she was questioning whether she had hit him, and to that extent.
Had you focused in on a target at this point or reached any conclusions about your investigation?
No, we were still in the information and fact-finding portion of the investigation. We are not ruling out people as much as we're not ruling people in as much as we're ruling people out. So we need to get as much information as possible that is in physical form, statement form, and circumstantial factors as well.
So where did the evidence take you next?
Following 3 interviews conducted in Canton with witnesses, we proceeded to the Good Samaritan Hospital because based on the information I learned, I needed to put eyes on Mr. O'Keefe and his injuries. I need to see what exactly the witnesses were describing.
Do you remember who you spoke with that morning before you decided that you wanted to go to the hospital to see Mr. O'Keefe?
Yes, we interviewed Miss Jen McCabe, Mr. Matt McCabe, and Mr. Brian Albert at the McCabe residence.
How long or about what time did you get to see Mr. O'Keefe?
We got to see Mr. O'Keefe, I would approximate probably like 12:30, maybe 1 o'clock-ish.
Why did you want to see him specifically?
I wanted to see the injuries for myself, the location of the injuries, the types of injuries, the extent of the injuries, and overall condition that his body was in would be very telling. The mechanism of injury, how it might have taken place, and also the correlation of any evidence at the scene with those injuries.
Now, you don't have any medical degrees, do you?
I do not.
How
No.
about biomechanical engineering?
No.
Do you have life and job experience in these situations?
Yes. 20 plus years of law enforcement investigating car crashes, pedestrian crashes, and 10 years in homicide.
Your role is not to make a diagnosis, is it?
No, it's not.
Is this information and your interpretation based on your experience important in guiding what you're going to do in the investigation?
Yes, it is very.
Do you ultimately get to Good Samaritan Hospital?
Yes, we do.
Okay, take us through what happens when you get there.
When we got to Good Samaritan Hospital, the driving conditions were treacherous. It took us 45 minutes from Canton Center, basically, to Good Sam, which should be a 15, 20-minute drive. At one point, I had to get off the highway because I couldn't tell if I was on the roadway, if I was off the roadway. So the guidance of trees on the side of the road through the town streets actually helped us guide the path to Good Samaritan. Once we arrived, we walked to the emergency department where Mr. O'Keefe was initially treated and where he remained. Upon arrival, we spoke with medical personnel who advised us that the defendant had at that point been discharged from the hospital, and that Mr. O'Keefe was still in the emergency room and available for us to view.
At that point, you said the defendant had been discharged. She was not the defendant at that point.
No, she was not, no.
Did you have a chance to enter a room or actually see Mr. O'Keefe?
Yes, I did.
Had he passed at that time?
Yes, he has.
When you walk in the room, what do you see?
When I walked into the room, I saw a medical bed in front of me. Mr. O'Keefe was covered with a sheet, as is typical with any victim that had passed. There was a pile of clothing to the left, at his feet to the left of the bed. I observed several injuries on him once I lifted the sheet, and those were documented with photographs by crime scene services, a member of the state police, who also met us at the hospital for that purpose.
So there were other members of the team that were there to photograph
Yes,
Mr. O'Keefe and some of the injuries?
yes.
How many people were in the room with you and Mr. Proctor when you were observing and viewing Mr. O'Keefe?
There was a total of 3 of us, myself, Mr. Proctor, the crime scene services individual. There was medical staff coming in, nurses asking us if there was anything that we needed to assist us with. But from law enforcement, it was 3 of us there.
Now, I don't want you to try to give us a diagnosis or provide us an opinion of the cause of any injuries, but rather I want you to share with us, as you're observing Mr. O'Keefe in that hospital room, what are you seeing and what is standing out to you?
I saw pooling of blood underneath his head. There was seepage of blood into the sheets. There was also swelling, discoloration, a large amount of blood pooling underneath his eyelids. There was no abrasions or injuries that I observed to that region. So to me, through my training experience, I took that as subdural.
Not to medical, not to any medical observations, but just you as law enforcement.
Yes, Your Honor.
I'd ask you not to give your personal interpretations of what you saw. Rather, I want you to share with the jury what you saw through your view.
There was also a tiny cut laceration to the eyelid area.
You're pointing to your right eye. Could you be
Yes.
specific, please?
Also on the left nostril, there was a very small laceration there. Both were not actively bleeding. There were a series of cuts and bruises to the right arm, which extended from approximately mid forearm up to the mid tricep area of Mr. O'Keefe, and they were concentrated on the exterior of the arm. There was no other injury or marks on the interior or inside of the arm. There was also a bruise on that same arm on the back of the hand. It was light in color. It wasn't a profound discoloration as the eyes appeared to me. There were also injuries to abrasion or cut scrapes to the knee, I believe.
Which knee?
The right knee. I apologize.
You had first described swelling in the right eye, and then you had just said the eyes. Could you be specific? Was the swelling in one or both eyes when you saw Mr. O'Keefe?
When I saw Mr. O'Keefe, the swelling was in both eyes. It might not have been exactly symmetrical, but there was swelling, discoloration in both eyelids of Mr. O'Keefe. There was also blood pooling in the cavity of the eyeball, both sides of the eyeballs.
Do you know about what time it was that you visited Mr. O'Keefe and made these observations?
It was sometime between 12:30, 1 o'clock, and 2 o'clock, I would assume.
You mentioned that there was pooling on the back of Mr. O'Keefe's head. Did you look for any injury?
Yes, we looked for injury. All I could tell, there was bleeding happening. I could not tell exactly what the extent of the injury was, not being a medical professional.
You mentioned there were a pile of clothes in the floor. Is that uncommon?
No, it's not uncommon at all.
Did you have any opportunity, or did you decide to look at those clothes?
Yes, what happens, the reason those clothes are on the floor is that for medical therapy, for medical treatment, the victim has their clothing removed for access to the body. There's obviously all sorts of equipment and medical procedure that's done. So that clothes is discarded. We knew that it was Mr. O'Keefe's clothing. We knew that it would be important to aid us in the investigation. So that clothing was picked up, identified item by item, and bagged. It was in a soaking wet state with moisture and other debris on it.
When you are looking at Mr. O'Keefe, do you have to touch him and move him?
Yes, during our investigations, we're not simply looking at photographs. We are there in the scene. We are smelling it. We are touching it. We are, unfortunately, with certain pungent scenes, we were tasting it. That's the reality of us breathing in the scene when we're living it through the investigation.
Do you wear any type of protection?
Absolutely. We wear gloves. At times, we wear other PPE, personal protective equipment.
When you looked at Mr. O'Keefe's clothes, you said that you bagged them. Did anything stand out in particular about his set of clothing?
In particular, we were missing a sneaker of his. That was very significant to me. It caused me to have Michael Proctor contact the paramedics that transported Mr. O'Keefe to the hospital and confirm with them, conduct a secondary check that that sneaker was not left behind in the ambulance.
Why was the missing sneaker significant to you at that point?
At that point, our theory had evolved to a vehicle strike based on the injuries, and I was suspecting that he was hit out of his shoes.
Is there a phrase that's common in these type of situations?
Yes.
What's that?
Knocked out of your shoes?
Did you know where the other sneaker was?
I did not, no. But I suspected, since it was missing, and once the reports came in that the paramedics, EMT personnel did not find the other sneaker, that it would be somewhere where Mr. O'Keefe was found or where he was initially struck by a vehicle.
Did you and Mr. Proctor have an opportunity around that time, 12:30, 1 o'clock, to go back to that address to look for the sneaker?
We did not know.
Why not?
Again, during the critical early hours of an investigation, timing is essential. We have to make sure we get to any and every location that could possibly have evidence and prevent that evidence from being destroyed, altered, or concealed. So we are prioritizing missions. And with the resources available at that time, I conferenced with my boss and advised him of the current status of the information that we had. And he stated that he would go out and marshal up resources to conduct a search.
Is this an example of the team approach of the state police at the homicide unit?
Objection.
After having this information, making these observations of Mr. O'Keefe yourself and bagging the clothes, where did the evidence lead you next?
At this point, once we viewed the clothing and Mr. O'Keefe, we had to go talk to the last person that saw him, and that would have been, at the time, his girl,
Who'd you go see?
the defendant, Your Honor.
The prior question wasn't answered, so prior questions.
Did you know where Miss Reed was at that point?
Yes, we had learned that she traveled to her parents' home in Dighton.
Did you learn about any, or did you have any interest in any physical evidence at that point?
Yes, with the missing shoe, her stating that did I hit him, and along that line of statements, I was interested in the vehicle that she was operating that night.
How far was Dighton from where you were at Good Samaritan Hospital?
Typically, I would say it's probably a 35, 45-minute drive. With the driving conditions, it took us all of an hour, 15 minutes.
Who was driving?
I was driving.
Were you in a issued vehicle or were you in a personal vehicle?
No, I had to drive my personal pickup truck due to the weather. My cruiser would have never made the unplowed streets of the area.
Was Mr. Proctor with you?
He was.
Were you by his side the entire time?
Mr. Proctor and I were together the entire day.
You decided to go or drive towards Dighton. Did you ultimately make it to Dighton?
Yes, we did.
Do you know what time you arrived in Dighton approximately?
Approximately 3 p.m.
On your way down to Dighton, did you learn any further information beyond what you had known when you had left Mr. O'Keefe at Good Samaritan?
Yes, at one point, Michael Proctor took a call from Jen McCabe, and she further elaborated and provided information stating that she remembered.
Sustained.
After receiving that information, is there something specifically you wanted to look at when you got to Dighton?
Yes, we wanted to look at the rear right tail light. Based on the information provided, it was allegedly to
Let me
be.
stop you there. I just wanted to know what you wanted to look at.
Yes, sir.
I don't want to relate conversations with somebody who's not here. And so you had an interest in looking at the right rear tail light.
Yes,
Do you know what type of vehicle you were looking for?
we were looking for a large black Lexus SUV.
When you made your way down to Dighton, you said you finally arrived. How did you know you were at the right address?
The defendant provided her parents' address to us.
Before you got to Dighton, after learning of new information and the information you already had, did you make any arrangements?
Yes.
Tell the jury what you did on the way down to Dighton.
On the way down, we contacted Dighton Police Department and gave them a heads up that we would be coming down for an investigation, and we were looking to most likely seize a vehicle, and we were requesting their assistance in contacting a local tow truck company that they were contracted with, and or also to assist us at the scene being a uniformed presence.
When you pulled up to the address, did you make any immediate observations while you were still inside your truck?
Yes, the road was not well plowed. There was only enough clearance for one vehicle. So it was difficult to find a place to park, and maneuverability was also challenging.
Did you make any observations of the home or the driveway before you got out of your truck?
Yes, the home is to the left of the driveway. The driveway was not plowed either. There was a large black Lexus SUV parked in the driveway.
Was the front of the SUV facing you or the back of the SUV?
The back of the SUV was closest towards us.
How far from the SUV were you when you first parked at that address?
Probably it's the length of the driveway. Based on my memory now, I would probably estimate it'd be 60 feet or so.
Did you make any observations of the SUV from that distance?
It was covered with snow, like it's been either sitting outside or driven outside in the snow. So it was exposed to the elements.
What was your next steps?
We waited for Dayton PD to arrive to assist us. Once they arrived, Michael Proctor and I exited and proceeded up the driveway. I told Michael.
Let me stop you with what you said. I want to just know what you observed.
Okay.
As you're walking up the driveway, how close to that SUV did you get at its closest?
At its closest, I got as close as me and the defense table, which is probably 10 to 12 feet.
From the 10 to 12 feet, did you notice anything remarkable about the SUV?
Yes, there was a large piece of red taillight cover missing from the vehicle.
After you made an observation of a large piece of the red taillight cover missing, did you do anything else relative to the SUV at that time?
Yes, I told Michael to get close.
I'm not interested in what he did. What did you do? What did you see?
I just saw the damaged, missing taillight cover. I did not touch it. We did not approach it with physical contact. So.
Did you see where Michael Proctor went?
Yes.
How close to the car or the vehicle did he get?
Within 3 feet.
Did he ever touch it?
No.
Where did you and Michael Proctor go next?
We proceeded to the front door of the home to make contact with the residents.
And how clearly did you see that missing piece? What's your level of certainty?
100%.
Did you knock on the door?
Yes, I did.
And were you invited in?
We were, but not through the front door due to the weather and the piled up snow. We couldn't open the storm door. Mr. Reed invited us into the home through the garage. He opened the garage door for us and welcomed us inside.
When you went inside, what did you see?
When I went inside, I saw Mr. Reed, Mrs. Reed, and the defendant sitting on the couch.
You've referred to the defendant a number of times as Miss Reed. Do you see the defendant here in the courtroom today?
I do.
And the person you spoke to that morning, can you point that person out and describe an article of clothing they're wearing?
She's sitting in the middle right there in front of me wearing a black suit with yellow colored metal buttons on it.
When you walked in, did you say that the defendant was sitting on a couch?
She was.
How close were you when you were speaking to her?
Within 12, 15 feet. We were in the same room, in the living room area.
Was Mr. Proctor there?
He was.
Was Mr. Proctor speaking to her?
He was.
Were you speaking to her at the same time or interchanging?
We were both communicating with her, a team approach.
I want to ask you about that conversation you had with Miss Reed. Before I do, Your Honor, may I approach briefly?
Okay.
First sidebar of the day, 49 minutes into the stream, and that would be 42 minutes into the court because they actually started like reasonably this morning. We are definitely in the upside down. Very little objections. I mean, I heard one in the beginning. Haven't been hearing a lot. Liam says, isn't the defense going to say that the damage was done when she was driving home or to her parents? Oh, they're going to try, but remember the photographs we already saw of the damage being done? Like, well, before that. Yeah, I know. It's still a sidebar, right? But hello, fan. Still pretty good. Only one in it, this much. And cameraman's going to give us a view of the galley. Paul O'Keefe still in row 2. Oop. Then just see Mrs. O'Keefe giving a little sideways glance, not so nice. It must be hard to sit there every day. It's hard on both the families, I think. Boy. Oof. I will note that Sergeant Bukhenik, he worked with Michael Proctor. Michael Proctor is being avoided like the plague by the Commonwealth. Although they brought him up because they know that he was part of it, but I don't think he's going to be called in. And I've been trying to research whether now that he's fired, he's allowed to actually come in and speak on active cases like this. I don't know what the precedent is there. I do know he's on the list for the defense, so we shall see. That's going to be quite the back and forth. There'll be some lawyering, some objecting, some motioning, some gesticulations going on if and when he gets to testify, if he does. But I think they are saying that the Commonwealth will be wrapping up soon. We still have quite a few expert witnesses that are on the list. We've got the Lexus information. We've got with the accident reconstruction people. We've got the medical examiner still. We've got and I don't know if they're actually going to be testifying because they are not going to say cause of death. So let's see. Beyond that, we still have, there are still on the list several EMTs and police officers, but they all seem to have the same information, so they may just be there just in case. I am very interested in the accident reconstruction, in the new information for the Lexus coming out. There seems to be some information that'll go right along with the digital forensic timeline that's been created. As far as evidence in Hank Brennan's opening statement, did he not say that it would be facts, science, and data? And he is pretty much keeping to his word and punctuating it with her own words whenever he can, which is unique, novel, and totally different from trial one, from what I understand. Hey, Jean. Good morning. This is the first sidebar. So long in. Actually, they started on time, like 7 minutes into my stream, which was only like 3 or 4 minutes after 9 o'clock, with the jury already in the room. And the judge in good mood. Maybe because they didn't have a sidebar. Nobody gave her a headache first thing. I don't know. I really want to see it. Let me just pull this up. I really want to see if the Lexus data eats into the defense 20 seconds. Oh, you mean the 86 steps, 20 seconds? Yeah, it would be hard to do that while she's backing up, wouldn't it? Seems pretty close to the time. Yeah. Oh, I know that was a bit snarky. Sorry. Not sorry.
All right, so is it appropriate for me to give an instruction right now, Mr. Brennan?
I would defer to counsel.
Mr. Jackson, you want me
I'm
to
not
give a
asking for one.
humane practice instruction?
Yes.
Yes. All right. So, folks, you're about to hear testimony regarding a statement or statements that were allegedly made by or attributed to Ms. Reed. I'm going to instruct you in more detail at the end of the case about this matter. However, I want you to understand that at this time, as the statements are offered into evidence, that before you may consider the content of any such statement made by the defendant as evidence, you're going to have to make a preliminary determination about whether or not it can be considered by you as evidence at all. In your determination, at the end of the case, you're not to consider any such statement by the defendant as evidence, even though it's presented to you through a witness at trial, unless from all the evidence in the case, you first determine that the Commonwealth has proved beyond a reasonable doubt that Ms. Reed made the statements she's alleged to have made, and that she made it voluntarily, freely, and rationally. All right. Go ahead, Mr. Brennan.
Okay.
Thank you, Your Honor. Sir, I want you to begin from when you were in the living room, your beginning conversation with the defendant, the presence of both her father and mother. You're with Mr. Proctor. Can you share with us the conversation that you had with the defendant?
Yes. She stated that she's willing to answer our questions, but she didn't want to go into too many details. That's how the conversation began. She provided us the fact that Mr. O'Keefe was hanging out with a friend of his at 5 p.m. at the One Meadows Ave residence, following which he proceeded to C.F. McCarthy's in Canton, where the defendant stated that she met him approximately at 9 p.m. She was drinking vodka sodas. Mr. O'Keefe was consuming Bud Light beer. After C.F. McCarthy's, they proceeded to the Waterfall Grill and Bar. At this point, the defendant was asked if she brought a beverage with her from C.F. McCarthy's to the Waterfall establishment, to which she stated she didn't think so. After the Waterfall, the defendant stated that she dropped Mr. O'Keefe off at 34 Fairview. She was asked if she saw him go in the house. She stated no, she did not see him go in the house. She was asked about the damage to her rear taillight, to which she stated, quote, "I don't know how I did it last night," end quote. Once she provided us with the fact that she dropped him off and never saw him go in the house, she was asked to provide details about her leaving. She stated that she made a 3-point turn and left. She was asked to provide some explanation of how Mr. O'Keefe sustained those injuries that he had. She did not.
Let me stop you there. Did you get an answer to your question about how he sustained the injuries or the details about the 3-point turn?
No, I did not.
You mentioned that when you were at Good Samaritan Hospital, you saw blood on the back of Mr. O'Keefe's head.
Yes.
Did you ask the defendant anything about that injury?
Yes. We asked about the injuries that Mr. O'Keefe had, that he had been displaying, and whether or not he had those injuries the night prior at either McCarthy's or Waterfall, to which the defendant stated she didn't see any injuries on him. But then she provided a statement saying that Mr. O'Keefe bumped his head 2 nights prior and asked her about it, which to me seemed kind of strange. But
without the commentary.
Mm-hmm.
After she told you that Mr. O'Keefe had bumped his head 2 nights prior and that he had asked about it or she had asked about it?
She stated that he had bumped his head 2 nights prior and Mr. O'Keefe asked her about it.
Did she say when Mr. O'Keefe asked her about the bump on his head from the few nights before?
No, she did not.
Did the conversation conclude?
Yes, it did.
After the conversation concluded, what was your next step?
Once the conversation concluded, the defendant was advised that her vehicle is being seized, and her cell phone was also seized.
Were there any other items at that point that you were seizing other than the cell phone and the vehicle?
Not from that location, no.
Did you have a warrant at that point?
We did not, no.
Did you have authority to seize items prior to having a warrant?
I'll allow that.
Well, what is the process when you want to obtain items but you don't have a warrant? What process do you go through?
We seized them to prevent any alteration, destruction of the evidence that could be contained on those items pending a warrant. They are secured. They're not touched or processed by us. The process of obtaining a warrant includes writing an affidavit justifying.
Yeah, we don't need to hear any of this part.
Understood. Did you ultimately obtain both the phone and the vehicle?
Yes, we did.
Describe how the vehicle was seized. What happened?
The defendant provided her key card. It's like a credit card size key fob for the vehicle to allow the ignition to start. It was driven onto a flatbed tow truck, secured, and then we followed it from Dighton to the Canton Police Department.
Was video ever provided that showed part of that vehicle being loaded onto the tow truck?
Yes, it was.
Have you ever reviewed that video?
Yes, I did.
When you were at Dighton and the defendant's Lexus was being put on the tow truck, about what time was that?
It was approximately 4:16, 4:15 in the afternoon on the 29th of January, 2022.
Now, you mentioned that you took a cell phone. Are there parts or participants on the team that handle that specific type of evidence?
Yes, we have troopers that are specialized, trained, and have expertise in digital forensic analysis, extraction, and processing of digital devices.
Is that something you do?
I am trained in certain portions of it, but I am not an expert like them.
Did you manipulate the phone in any way?
No,
Did you see Mr. Proctor manipulate the phone in any way?
I don't recall seeing that, no.
Before the vehicle was moved or during the loading of the tow, did either you or Mr. Proctor go back anywhere near that vehicle?
We were near the vehicle once it was unloaded, but we never touched it.
Okay.
He's laying the foundation for the videos that shows them in the Sally Port when the vehicles arrived. Because the defense wants to insinuate that Michael Proctor planted all of the tail light pieces in that he set her up, because of the text that we heard previously through the socials in the first trial, where one of the reasons he was fired was for being very unprofessional. Michael Proctor is not a witness so far for the Commonwealth, so we don't have any of that to go by. But the defense doesn't want the foundation laid for it all to look like bullshit when they bring up their case. Sorry to be so blunt about it, but that's exactly what it is. If there's a strong enough foundation with this witness, which is totally credible, which they even objected in the beginning to him saying that he was in the Marines and how he got his training. They don't want him to look too good, because if the jury believes him, anything they say about Proctor really isn't going to matter, because this is the man giving the testimony, not Proctor. So it's a game. At least now, I have to say, this is not shenanigans. This is not even theater. Actually, what's happening today is damn good lawyering. For a change. Nice to see. Quiet objection, reasonable objection, valid objection when you look at their side of the story and their case that they want to present. It's about damn time the lawyers have entered the trial.
Jurors, I'm going to strike the last portion of that testimony.
From the point you went in and spoke to the defendant until the vehicle was placed in the back of the flatbed, did you ever go back near the vehicle and touch it in any way?
No,
Did you ever see Mr. Proctor go back near that vehicle and touch it in any way?
no.
You mentioned that the tow was loading the vehicle, the defendant's Lexus, around 4:15.
I believe so, yes.
Did you join the tow truck driver or did you keep your separate vehicle at that point?
We traveled in my,
I'll allow it.
I drove my vehicle and followed the tow truck back to the Canton Police Department
Where was Mr. Proctor?
in my front passenger seat.
During that time, had you made arrangements or did you receive any information about other members of the team engaging in any searches relative to this case?
Yes, I have.
And what did you learn?
I learned that Detective Lieutenant Tully had
I'm going to allow it.
had dispatched other members of our unit to 34 Fairview and other resources from the Massachusetts State Police to assist him in a search for the missing shoe.
Do you know what time those other members arrived or began to arrive at 34 Fairview?
Objection.
You begin your travels at 4:15 p.m. back to the Canton Police Department. Why did you choose to bring the vehicle to the Canton Police Department if the Canton police detectives were not working on this case anymore?
They had a heated storage facility, being the Sally Port. We needed to preserve the vehicle as best we could away from the elements. And it was also in close proximity to our office, also to process the vehicle and get the search warrant from the local courthouse would have been more convenient for us.
Why was a heated Sally Port or a heated garage important to you?
The vehicle was impacted with snow that accumulated, and also from traveling on the highways, it was packed with a shell of snow covering the exterior of it. So it would melt away in the heated Sally Port.
Were you intending on having other resources or other team members or other units available to look at the vehicle at some point?
Yes, we were.
Who were you intending? Who did you expect would have to look at the vehicle in the future?
For one, we'd have to document the exterior of it with photographs. That would be crime scene services section. We would process it for fingerprints, which would be also service the crime scene services section provides. We would, if needed, take swabs for DNA or other latent evidence. So that would be the chemist, as well as if the authority was there to process the internal workings, the computer chips, and the infotainment system of the vehicle. And that would be a digital forensics expert that's trained in that field.
Would an unheated garage or Sally Port impede that?
Yes.
Given that Canton Police Department was not now part of the active investigation, did you have any concerns bringing it to the Canton Police Department?
No.
You said you left Dighton at 4:15. What time approximately did you and Mr. Proctor and that Lexus arrive at the Canton heated Sally Port garage area?
We arrived in at the Canton Police Department at 5:30, and the vehicle was unloaded and placed into the garage at 5:35
Did
p.m.
Did you and Mr. Proctor go into the garage?
Yes, we did.
And in the garage, what were you doing?
We helped facilitate
I'm
putting
gonna- I'm going to ask you what you were doing and then what you saw Mr. Proctor doing rather than use we. I want to be very specific about what you did and saw. What were you doing?
I helped put up yellow caution tape around the vehicle to prevent anyone from coming near it and touching it.
Were there any other persons in that area other than you and Mr. Proctor?
There were members of the Canton Police Department.
Did you make observations of the vehicle once you had it in that Sallyport area?
Yes, I did.
You mentioned that it was packed with snow. Was the snow still on it when you brought it into the Sallyport?
Yes, there was.
Did you wipe the car down or clear
No.
the car of the snow?
No,
Did you touch the vehicle in any way with your hands?
no,
Did you ever see Mr. Proctor touch that vehicle?
no, he did not.
Objection.
I'll sustain it.
It's a strike.
I'll strike that, ask you differently, Mr.
Did you ever see Michael Proctor touch that vehicle while you were in the Sallyport area?
I did not.
How long did you remain in the Sallyport area for, do you know?
We remained in the Sallyport area approximately until 5:51 and change, based on
Okay,
the
that's
best of
enough.
my memory.
After you left the Sallyport area, where did you go?
We left the Sally. I apologize.
Go ahead, if you can say first what you did and then wait for the next question, please, Sergeant.
I left the Sallyport area and proceeded inside the Canton Police Department.
Where was Mr. Proctor?
He was with me.
By your side?
Yes.
Did he ever leave your sight?
I'm sure at some point he walked away from me, but I can't. We were traveling together all day.
You went into a different part of the Canton Police Department?
Yes.
Where did you go?
Into the dispatch area, and then the conference room upstairs later on.
Why did you go up to the conference room?
The conference room was provided for us to use as a meeting location. The members of our unit that had assisted at the 34 Fairview Road scene had traveled back to Canton Police, and we were meeting there to exchange information based on what we had learned with our portions of the investigation. That way everyone's on the same page at that point.
Did you meet, is this team, is it called a CERT team?
There is a CERT team.
Do you know if the CERT team was the team that went to 34 Fairview?
Yes, I do.
Did you meet with the entire CERT team that night at the Canton Police Department or some members?
Not the entire team, no.
When you had the meeting in that room, who did you meet with?
In that room, I specifically remember being Detective Lieutenant Tully, myself, Michael Proctor, and other members of our homicide and narcotics section assigned to the Norfolk District Attorney's Office.
Did you discuss the evidence you had to that point?
Yes.
Regarding 34 Fairview Road, did you develop or decide any plans to physically go back to that area?
Yes, I did.
And what was the plan?
The plan was to take shovels and rakes and other gardening equipment and go back to that location to excavate for additional evidence.
When did you make the decision that you were going to go back to 34 Fairview?
It was that evening.
Why did you decide you were going to go back at some point?
During the recall of all the information learned and sharing of that information with other members of our investigative team, It was realized that Mr. O'Keefe was wearing a black baseball hat, and at this point in time, that article of clothing was still missing.
Was there something impeding a full and complete investigation of the scene?
At 34 Fairview?
Yes.
Yes, the heavy, large amount of snow that had accumulated over the last 12 hours or so heavily hindered our investigation of that immediate scene.
When you were debriefed, did you learn the area where the search team had spent most of their time searching?
I'm sorry, can you repeat that, sir?
When you were debriefed, were you informed the area that the search team spent most of their time searching?
I don't recall on the specifics of it, no.
Now, at some point, did you obtain a registry of motor vehicle record and certificate for the Lexus that you had towed?
Yes, we did.
May I approach?
Yes.
So do you recognize this?
Yes, I do.
And if you can take a look at the following pages. And what is that, sir?
It is the Massachusetts Registry of Motor Vehicle title, history, and registration inquiry for a black and color Lexus LX year model 2022, bearing Massachusetts registration 3GC684, registered to Karen Reed.
Trying to this document as evidence?
No objection, Your Honor.
Thank you. As part of your continued investigation, did you have an opportunity to obtain documents and items?
Yes,
Did you listen to audio recordings that were included statements of the defendant?
yes, I did.
Did you listen to audio recordings from different sources?
Yes, I did.
What do some of those sources include?
Dateline 2020, Gretchen Voss, Fox 25, various media platforms.
I want to walk through some of the evidence in chronological order of date. So going back to June 29th, 2022, at the hospital, you obtained some items.
Yes, sir.
Did you bring those items with you today?
Yes, I did.
I want to talk about the progress of those items from when you first obtained them until today. You mentioned that there were clothes that you obtained at the hospital of Mr. O'Keefe,
Yes, sir.
and you shared with us that they were wet. You put them in bags.
Yes, sir.
That night, where did those clothes go when you left the hospital?
Those clothes, while bagged up, they remained in the back cab portion behind my driver's seat of my pickup truck on the floorboard.
Where did you bring them that night?
That bag containing all those clothing traveled with me around the area as we investigated. And then after the debrief at Canton PD, we brought them directly here to the Canton office of the district attorney.
Did you have those items with you at the Canton Police Department?
They were in my truck. I didn't bring them into the
I see.
the
They
office.
remained in your truck while you were in the Canton Police Department?
Once I placed that bag in the back of my truck, I did not touch until I removed it from the truck at the Canton District Attorney's office to bring it in.
When did you remove it from your truck and bring it into the district attorney's office?
Probably around 8 p.m. on the 29th of January 2022.
When you brought the clothes inside, where did you bring them?
We brought them to the temporary evidence processing area within the district attorney's office in the state police section of the office, where we have our desks and workspaces. There's a designated area at the time for evidence processing.
What did you do with the clothes once you got them into the secure area in the district attorney's office?
Once the clothing was in that secure area, we had to lay them out to dry.
What you did, if you could.
I had to lay them out to dry them. So I took a butcher paper, laid it out on the floor, and each item I removed and laid out onto that butcher paper to dry.
Was anybody with you helping you?
Yes,
And who's that?
Michael Proctor.
Why did you lay out the clothing items one by one separately?
Each clothing item needs to dry naturally and prevent moisture from being trapped. That moisture, if trapped, could develop mold and damage any DNA evidence that we could retrieve. Scientists could retrieve from the item. To prevent that, we dried each item individually, separating each item for better airflow.
How long did it take for those items to dry?
Several days.
And were they in that secure area on the butcher paper for several days?
Yes, sir.
Are there times when that separate area was left alone, nobody watching?
Yes, sir.
Were those clothes ultimately moved from that area?
Ultimately, they were moved, yes.
Did you personally remove them from that area?
No, I did not.
Did you know if they were bagged and put into evidence?
I do know they were bagged and put into evidence.
Is there an evidence locker at that office?
Yes, there is.
Is it a secure area?
Yes, it is.
Does every officer or trooper have access to that evidence room?
No, they do not.
Did you again see those items at a later date?
Yes, I did.
And have you seen those items since?
Yes, I have.
The items, the clothing items you took from the hospital, do you remember what items they were?
Yes, I do.
Can you share with us your memory of what items they are?
It was a two-tone gray sweatshirt, light material sweatshirt. It was an orange t-shirt. It was a pair of blue jeans, a belt, and a pair of underwear boxers.
And did you bring those clothing items with you today?
Yes, I did.
Beginning with the pants, do you have them with you up at the stand, Mr. O'Keefe's pants?
Yes.
Could you produce it, please?
Yes, sir.
Do you have gloves, Trooper Bukhenik?
Yes, I do.
I'd move this item into evidence.
No objection.
With the court's permission, I'd ask the trooper to show the item to the jury.
Yes. Go right ahead.
Thank you. May I approach, Your Honor?
Yes.
Did you learn during your conversations with the CERT team and other members of the team that a sneaker was found at 34 Fairview?
Yes, I did.
Have you seen the photographs relative to that sneaker?
Yes, I have.
And you mentioned when you were at the hospital, there was a sneaker? One?
Yes,
Do you have that sneaker with you?
I do.
Could you produce it, please?
Yes, sir.
You all right, move this item into evidence?
No objection.
Could I have the court's permission for the trooper to show it to the jury? Trooper, is that the sneaker that was at the hospital when you visited Mr. O'Keefe?
No, sir. This is the sneaker from 34 Fairview.
Could I have that marked? What, is that a left or a right sneaker, sir?
This is the left sneaker. Excuse me. This is the right sneaker from 34 Fairview Road, Kansas.
Yes, Your Honor.
Sure. If you could put the speaker back in the bag and let Mr. Brennan bring the bag over, please.
There's been some scuttlebutt back and forth that the shoes are different all over the socials, but I don't really see it. There also seems to be some confusion into the documentation of which one was from where. It sounded to me like Brennan was entering the one taken from the hospital, but the wrong bag is up there. It happens. The link I just provided to you, I just saw that Judge Cannon had put in a privacy order that the media is not to photograph or put out any images of John O'Keefe's niece and nephew because they are going to be testifying. And to me, this seems very bad for the defense. I do not believe they testified in the first trial, but they both had interactions with Karen Reed. They are going to be able to testify as to the status of the relationship, which has gone back and forth between whether they were breaking up or whether they were a happy couple, as I do believe Alan Jackson went on a bit in the opening statement about how they were just a happy couple. And to most eyes, it did appear that way. But there was some stuff going on. Also, Karen Reed woke up the niece. She was the one home. Her interactions in the house directly when she got home from dropping John O'Keefe off at 34 Fairfield, as she states, and her interactions afterwards, arriving at the house, calls back and forth, the call to Jen McCabe and Kerry Roberts. The niece was there. Jen McCabe called the niece. All that interactions coming in with more witness testimony from the niece. It's going to be interesting. Thank you for checking, Liam. I don't know. It does appear that because it's the shoe, it was the wrong bag. It was not the one from, back and forth. I mean, they both were. It was already entered into evidence. It's not really that big of a mistake. As long as they enter the next one in, everything is there. They just probably pulled the wrong bag, left or right shoe. One was retrieved at the hospital from the body. The other one was retrieved at 34. We know the CERT team discovered that one. Yeah, it was opened yesterday, and it should say so on that bag. And we shall see. But just when we thought things were going to calm down, right? Well, I have to say, I'm impressed. It's calmer today, and there's some good lawyering going on. A lot less shenanigans. I don't know if they all had a talking to, but it does appear that there's some good lawyering instead of all the shenanigans. I would think if they saw the socials after Alessi, who is normally an excellent, very diligent attorney, and he was getting blasted on the socials for just being overly angry, yelling, not making any points, not actually doing lawyering. And I don't think a lawyer ever wants to hear that they're not actually lawyering when they're there doing their job. So, I don't know. Ugh.
Watch us over there following the thing, so we'll take a half an hour just to make sure that everybody
Half an hour. Oh, ye.
move forward smoothly. These things happen. We need a lot of
I guess they're going to be having a discussion.
All rise, please. Jurors, close your notebooks, follow me.
All right, Yuri's coming back at 11. That's a long break. I don't think we're going to be on break the whole time. Sounds like there's going to be lawyer discussion. I seen some motion or something. I don't know, but whether they're checking evidence or. The witness immediately showed that he was given the wrong bag. 1 point towards dishonesty. Exactly. You know what? In correcting the issue. Yeah, Maggie, I saw it. It's no way. We understood what you meant.
Right back on.
Your Honor, may I?
Yes.
be heard?
Yes.
Okay, here we go.
May I, during the break, in the company of a representative from the defense team, speak to Trooper Bukhenik about this issue?
I have no problem with that. Do you, Mr. Jackson?
No, no problem.
Oh, they're going to go over the evidence. Okay. Well, because the judge isn't there and it's not active court, we're not going to be able to hear that. But apparently, they're going to work together to resolve this issue and get the evidence corrected. And then they're going to do something about that, and she'll come back earlier before the jury. Well, we got 30 minutes to kill. So what do you guys want to talk about? There. In regards to this case, it is getting there. I am surprised that the niece and nephew are testifying. I think that's going to be very difficult for them, but it's very brave of them to do it. And I think it's very important for the case, actually. When Hank Brennan decided to go consciousness of guilt for the direction of his case in chief, things changed. All how he presents the end. Of course, he's going to do, like he said, he's going to do facts, science, and data. But facts are going to be every witness he can to streamline the timeline and her actual state of mind and what Karen Reed has actually said about all of this. Currently, they're in the court, both the defense and the Commonwealth, dealing with Sergeant Bukhenik and the evidence. I saw Bukhenik right there with the evidence. They were getting ready to look at the bags to which one was the shoe and which one, and they were going to talk together. So they're there in the court, but not on camera. But it's not on record because they're dealing with it before the judge comes back in. Then they will put the resolution of whatever happened on record. Does that make any sense? But they're, it's not often. I mean, it is often. It's very calming that they would work together, ex parte together, having a meeting without the judge there to try to work it out for both of their sides equitably. I think there was a sidebar before we went on break, so it does count as 2. Count, you are correct. They absolutely love their Uncle Maggie. He was a surrogate father to them. He'd been with them for years. He raised them like his own. Oh, you meant the niece and nephew? I'm sorry. So they're going to be in court, but not on camera. The media is instructed not to actually take any image of them on the witness stand. That's correct, Liam. If you read the order, it's going to be very limited view. I do believe we will hear them, though. Let me just double check what that says. See if I can make it bigger. It says the media shall not film, photograph, transmit, or audio record the minor witnesses at any time. Oh, we are not going to hear it. The media shall not film, photograph, transmit, or audio record any exhibits containing prior interviews of the minor children. If disclosed in court, the media shall not disclose the names of the children and their guardians, nor the schools the children attend or the town they live in. In order to ensure the safety and well-being of all trial participants, particularly the minor witnesses, conformity with Supreme Judicial Court Rule 119, and the dignity of the proceedings, the court enters the following orders regarding media and journalist coverage of the testimony of the minor niece and nephew of the deceased, John O'Keefe, and any exhibits that may contain prior recorded statements the children have made. And the Commonwealth brought this order forward, and the judge agreed and signed it. Not me. Since the YouTube commentators keep claiming they are media. Listen, that would pertain to us too, because we're using the news media feed. And so even if it does get captured, we should not retransmit it at all. I'll be very, very careful. And you know what? They may have that in closed session. And then enter it, with just the jury. They may clear the courtroom and they may not have any cameras. And I don't blame them. When it's minors, it's serious. And especially in this case, with the amount of harassment that has been well documented through trial 1, through the break between the trials, and even during trial 2. The judge is fully aware of what has happened to witnesses in this case, in the conduct of others outside. Is she going to protect those minors? Absolutely. They will more than likely have a blackout, a brownout day. They will, tell us what they're doing, and they will do it for the jury. That's it. We may get transcript. Journalists may be allowed there to document the statements, but they're not going to be allowed to release any recordings of the children. They may be able to release the happenings of the courtroom. After all, Massachusetts is an open transparency state for court proceedings. And so they will be able to say what happened in the courtroom, but there'll be no recording, audio or video of it for the media at all. So we'll have to get it from the socials because there are quite a few reporters that are in the courtroom that are actually putting stuff out on the socials, on Facebook, on Instagram, on TikTok, on X. So we will be able to possibly, depending on how long that testimony is, still be doing the live and still be able to have some commentary in regards to what's going on and inform you. We'll do our due diligence. We'll try. We've had this situation before where there was a witness that couldn't be shown and we had to just wait and just take what was coming out of the courtroom. And we have to do it with all of the states that do not actually have open transparency court laws, like New York, for criminal cases. We have to do that with the Sean Combs case. We wait to hear what happens in the hearings from the reporters inside. They give us an update. We had to do that with Danny Masterson for quite a bit of it. We would get a lot of reporting from Tony Ortega and from those inside the courtroom. I mean, there's a, you got to do what you got to do. But I would want their rights to be protected. It's the right thing to do. But I would imagine the news of this is not very comforting to the defense. I would imagine it makes Karen very nervous. The other filing that happened recently was that the Commonwealth is bringing in a officer of records from Ring Camera in regards to John O'Keefe's Ring Camera. There were some deleted devices. They're saying that they were deleted from, the defense is putting out there through interview and innuendo, not through the court yet, that those were probably deleted by the Alberts in their big cover-up, However, the children will possibly be testifying, as was recorded in interviews, that Karen Read had access to the Ring camera documentation through the home computer, that the only access was not through John O'Keefe's phone, and possibly those records, and this is only possibly, I'm just thinking as to why they would be doing it, to show who deleted or from what device these Ring videos were deleted, because the one that shows her backing up into the vehicle is there. The one with Jen McCabe and Carrie Roberts showing up at the house is there. All the ones prior to Karen showing up after 12:30 back home until she left, it doesn't even show the one where she's leaving at 5 something to go driving to Carrie's. So it's a little sus that those are. It does, the consciousness of guilt timeline that Hank Brennan is laying out. This makes sense that you would delete the videos that you can't control that make you look bad, but the ones where you're staging, oh, I bumped into this vehicle, and oh, here's the people, that I came with, and they're helping me look for John. Like, when she's working on alibi and the story. I know that's just my jaded reference towards consciousness of guilt, which I do believe that this defendant shows regularly in her actions, because to me it doesn't really matter what she says. I'm watching all the actions, and all the actions that get documented as facts through the timeline that are corroborated in more than one way. Those are the things that matter. When you're looking at the timeline that the Commonwealth is sending out, keep in mind the most important times are the ones that are corroborated by outside context in things, not just one thing. Like when Alessi brought up the 86 steps to Jessica Hyde yesterday, and she clearly just said, yeah, well, it could be that, but it would have to be proved with other items, outside. It doesn't make any sense. You cannot just take a notification from the health app as that's what happened, because it's not always steps. It could just be moving the phone. So same thing, all of those times. We're looking for the missing 20 seconds that Alessi is like, apparently John O'Keefe was able to make it into the house, get beat up, and get dumped back there. They're talking about temperature on the phone. It's going to be very difficult for the defense to put anything on that, because the important fact is not the time or how much it was. It is the constant decreasing of the temperature in a steady rate from point A to B, point A being when he hit the ground on top of it. It was found under his body. In point B being when they actually discovered the body, the actual phone was removed from underneath his body and it started to warm up and move. That timeline showing when the phone stopped moving and started to decrease in temperature is just solid. Yeah, it was Rocket Couch. And they said that could have been moving. I mean, for all we know, that was him getting out of the car and walking around to the back of the vehicle. Hey, I'm just saying. And the jostling could have been him moving around in the front seat to get the 2 drinks, his and hers, that he walked out with. Remember, he took her drink out of the cup holder. Okay? Could have been him undoing the seatbelt, phone in hand, moving around. That 20 seconds looks like 86 steps. Could have been a couple steps. Could have also been a lot of other movement. Could have been them driving in the car. It depends on where it is in the timeline. And the only place it's documented is the health app. She definitely made sure that was known. And the health app is not like a standalone for facts, science, or data. It can give you data, but the data has to be backed up with stuff. How would the health app record flying through the air and landing in a snowdrift? Maybe with 86 steps, turtle moves. We're saying, like, depending on where it is in the timeline. What's really going to help define some of those or limit some of those possibilities is going to be the Lexus's information coming right from the Lexus vehicle computer itself. And we'll be able to match up some things in the cell phone's timeline that they've laid out. That's why an integrated, you know what, I agree. And I'm hoping that once that comes out, we will see that in accident reconstruction. Because after all, it should be, right? The phone was in the vehicle at one time. And the phone is on the victim at the time. So I would like to see that when they do the accident reconstruction, but we shall see. I don't know what kind of witness it's going to be with the data. Also, welcome, Turtle Moose. We're killing time. Yeah. Because today is upside down day in the Karen Reed case. Because we started the day with no sidebar, believe it or not, Turtle Moves. No sidebar. And on time. The lawyers are working together and being polite, even when they object. So. I'm trying to think what else, about her testimony. I was trying to think of what about the cross was good for the defense, because I don't want to always just be highlighting, I mean, it was bad. When Alessi opened the door for Hank Brennan to come back about the 86 steps, that was a bit of a misnomer on his part, because, like, she explained that health, that data, including step counts, is influenced by so many factors, and it's not always accurately reflects actual movement. She noted that kind of data can be affected by the phone's sensors detecting motion. And it might not necessarily be due to just walking. It could be if it's moved or jostled. Even if the user isn't actively walking, it will say walking or steps, but it's not. She emphasized the importance, and this is the big part, of analyzing the context of the data, including timestamps and associated metadata, To determine the reliability of the step count, she cautioned against drawing definitive conclusions solely based on the health app's step count without considering other corroborating evidence. And I almost was going to jump out of my seat. That was like the best. Because that goes for all the evidence. All of this reasonable doubt, okay, that they're trying to put out there, all of this chipping away at things. A jury needs to be able to look at that little thing just because they say, well, we don't believe what the expert, and I mean they, the defense, is going to put the case that we counter this expert, and we think that Jen McCabe did make that Google search at 227 because she needed to know when they put the body out there if he was going to be dead, or whatever. Part of the conspiracy, part of Jen McCabe helping them cover up what just happened 2 hours prior, what happened inside 34 Fairview, according to the defense. So, but they have these little tiny nuggets, and with every little tiny statement they made or nugget about why you should not believe something, there's nothing around it to help make it seem reasonable or possible. Do you know what I mean? Like, except for like, this one's related to this one 3 times over. They know each other. They went to high school together. Stuff like that. Well, is that credible? You know, Robert Alessi questioned Hyde for a real long time on methodology, the reliability of what the health data showed. See, here's the thing. He questioned her on the reliability of the health app data, but then he wanted to use the health app data to benefit them by saying those 86 steps existed and he walked into the house. Don't think so. He's trying to say that O'Keefe was alive at the time and moving after Karen Reed left. Okay. Because the prosecution is alleging that he was fatally wounded right prior to that. So Alessi opened the door by asking her if her analysis accounted for all possible explanations for those particular recorded steps, leaving the door wide open for the prosecution to get a detailed answer out of her. Because remember, when she was answering, he kept shutting her down. He was really trying to narrow her answer down specifically. Because she just wanted them to know that they need to interpret that cautiously and take consideration of the broader context of the case and any supporting or collaborative information to go with it. You could not just take that. Pretty much, documenting that it was John O'Keefe's phone. The Faraday bag, was a bit of an issue. Alessi brought that up, that they did not Faraday bag the phone. But she did get to state on stand that although that was normal practice to do that and best practice in most cases, with the deceased owner of the phone may not be, because they kind of need his fingerprint or his face ID to open the phone, since he can't give them the passcode. So she did get to say that, and I heard that. But it wasn't as loud as Alessi yelling about how bad it is not to have a Faraday bag. But anyway. She was also able to confirm in the redirect that there was no tampering with the phone, no deleted files or extra information added after, which was good because she got to say that they looked for that and it didn't happen. That the reason that the Faraday bag was not used was, there was a good possibility as to it being because the owner of the phone was deceased. There's also the evidence that nothing was really tampered with. The files were all checked. She checked databases before she even does any of her compiling of the data. So I mean, she was very thorough. She even made a Star Wars joke. I mean, come on, you got to give witness credit. They do a Star Wars joke. But today we're just continuing with our timeline. And we have the first investigator involved in the case that had direct contact with interviewing Karen Reed after the fact. Not at the scene, which was done a lot by local Canton police and the EMTs. We heard all of that. This is after the fact, in true investigative style, an interview with someone, a casual conversation, not formal, not drag them down to the police station, all that stuff. Well, regular follow-up. He's going on about the signature. Well, all about, because they say that proves that Jen McCabe was part of the cover-up, or trying to help them cover it up. That Karen didn't ask her to do that search at 6:00 in the morning. That if that search is tainted because of what it says, how long to die in the snow, that they could have been researching that from the house, after the fact, to try to set Karen up. Seriously, that's exactly where they're going with that. We know that the stepdata can be wrong from the Murdaugh trial, where they tried looking at stepdata from the mother's Fitbit. Exactly. And also where it said he was walking while he was throwing the phone out of the car. Yeah. The signature thing was kind of funny. The hash is the signature. It's not a thing you sign, you do. That wasn't it? Like, she actually said that's not a valid question. Did she at one point, Rocky Couch? Like, she actually said that's not a valid question. Like, you need to, like, I don't know what you're trying to say, because none of that really exists. And then she corrected him on his lack of terminology and understanding of how things were. Like, he was trying to misrepresent stuff, and she was not going to have it. Yep. He was going on about a lot of things that I didn't really think were pertinent, but he's supposed to muddy the waters and cause doubt. But the way he was doing it was just like, every once in a while he would yell a word louder, and it was really grating. Like, he startled me quite a few times. I think after Jessica Hyde's testimony, the whole misrepresenting the Google search to be at 2:27 instead of when it actually occurred, I believe it was 6:04. I think that's dead now. Like, I don't really think they're going to be able to do anything, especially after I heard Alessi said they weren't sure they were going to bring their expert up, Robert Green. I mean, I wouldn't, after we know that he contacted Ian Whiffen, and he knows the Celebrate issue was resolved. And to hear how Jessica Hyde tested everything with all these different softwares, and did actually say in one of them that the actual timestamp still did exist, but it does exist properly by showing that it's part of the wall file, not as part of a search file. Yeah. She was really, really calm. She'll. All right. Okay. All right. She was very, very calm. I do agree. Sorry about all the clicking, just messaging. I thought that she really recovered. She was pretty much attacked, but she was calm. And did you catch? I did catch a couple of the questions, and she gave the jury a look like, "Can you believe this?" You know, and I was just like, "But she was on it. She was quite clever, you know." And it's not easy to give out such technical information to people that you don't normally give technical information to. Well, because she's a professor, she was able to actually speak of it in terms that was easy for many to understand. And from what we saw in the socials, the jury was taking a lot of notes. And although there are those on the other side that say that it went on and she made a fool of herself or whatever, I don't really see that. I think it was informative, direct. She was professional. She was charming and polite, calm. She didn't get ruffled. She's secure in the knowledge of what she was saying, you know. There was even one law YouTuber that said that she actually didn't confirm it didn't exist, but I heard the words that she said that search was actually performed at 6:04 in the morning to the best of her ability based on all the information available from the different databases and how everything was laid out. And she went out of her way to show how it was appearing in the logs as 6:22. So there you go. Yeah, very forthcoming. If she didn't know something, she didn't. Well, when Alessi was taking like one word from one artifact and trying to like apply it to something else she said, she stopped him cold by saying that statement was in regard to that artifact. And then tried to give him the reason as to why, but he kept cutting her off. And I think the jury could see. I think the jury could see. I always wonder how juries will interpret what they see as far as manipulation. It is their job on both sides, the Commonwealth and defense, to manipulate the story to their best view, to get that understanding to the jury the easiest way. They're both manipulating information to portray their side accurately or sufficiently. Well, do they see it as over manipulation if there's nothing there, like some of the stuff we've seen the defense do? I'm wondering how they react to that. Yeah, exactly. If the free Karen Reed people are saying that she's geeky, really, or just like if that's all they got, they are just awful. There was a lot talking about her looks and her demeanor and stuff, like really personal attacks. You know how I feel about that. If you've got to go low like that, like I do follow the Eleanor Roosevelt quote on that. If you're talking about people that way, those are small minds. You know, those fully engaged with all their
You are
brain are
unmuted.
usually talking about the issue. And we're back.
Okay, the jury's coming over, but did you want to give me those text messages or no?
You see the court is session. Thank you.
I don't need to have them.
No, I had brought them downstairs. I thought you had them. I will.
Did that fall out?
That's fine, sure. You can cheat play fishing in Discord. It does seem to be a much more polite court today. I'll tell you that. At least there's some good lawyering going on. I'm happy to see that. It only took a couple of weeks, right? Then again, I shouldn't really count my chickens, right? Because there is going to be a cross. Who's been objecting? Was it Alan Jackson, I believe? And that means he'll be on cross. Whoever was doing the objection. I'm not sure if it was Yannetti or Jackson. It does look, but the fast blinking that Alessi was just doing, and he handed a document to Alan Jackson. And I'm wondering if that is what we just read that was filed by Judge Cannone for the Commonwealth filed and was actually
All right, so the court, German's entry.
approved by Judge Cannone today in regards to the niece and nephew. Whatever it was, that fast blinking makes me think that it's something they're concerned about or that they have to change something. They did, didn't they? They do keep moving people next to Karen Reed.
Court is back in session. You may be seated.
Are you all set, Mr. Brennan?
I am, thank you, Your Honor. May I?
Yes.
Sir, when we left, we were discussing Mr. O'Keefe's sneaker that you retrieved from the Good Samaritan Hospital.
Yes, sir.
Would that be his right sneaker?
It would be his right sneaker.
Do you have that sneaker with you today?
I do.
And again, could you open that bag and show that right sneaker to the jury?
Yes, sir.
Is that the sneaker you retrieved from the Good Samaritan Hospital?
It is.
I'd move that into evidence, please.
Okay, any objection, Mr. Jackson?
No, Your Honor.
All right, thank you.
Trooper Bukhenik, there are two more items. I'm sorry, Your Honor.
Okay, go ahead.
Thank you, Your Honor. Trooper Bukhenik, there are two more items that you retrieved of John O'Keefe's clothing from the Good Samaritan Hospital. Did you bring those two items with you?
Yes, sir.
Are those two of the items that you laid out on butcher paper to dry?
Yes, they are.
Were they ultimately bagged and put into evidence?
Yes, they were.
And did you bring Mr. O'Keefe's T-shirt?
Yes, I did.
Is it placed in an object so it can be seen?
Yes, it was.
What type of object?
Say a transparent plastic sheet.
I would move the T-shirt into evidence.
No objection.
With the court's permission, could Trooper Bukhenik show it to the jury?
Yes.
Could you show the back as well, Trooper? Thank you.
Mr. Brennan, could you help assist the court reporter with that, please?
Of course.
Exhibit 87.
Oh my,
Yeah, that'd be great. Thank you.
that is an interesting way to present the evidence. Very sealed, very visual.
And Trooper Bukhenik, is there a last piece of item of Mr. O'Keefe's that you took from the Good Samaritan Hospital?
Yes, it is.
And what is it?
It's the sweatshirt.
I'd move that into evidence, Your Honor.
No objection, Your Honor.
The court's permission.
Yes.
A little awkward to hold up, but there you go.
Could you show the backside, please? May I approach?
Yes, thank you. Next exhibit, please, Madam Court Reporter.
Exhibit 88.
Thank you.
Your Honor, that's exhibit 88, maybe,
I'm sorry?
maybe.
Yep.
Oh, okay.
Sidebar number 3. Is it number 3 or number 4? I think it's number 3. Wait a minute. I lost count. Rocky Couch, I need your help. I have to go look back into the chat. I think the last one was number 3. Oh, this is number 3. That's what I'm thinking. Thanks, Couch. Yep, number 3. Let's just like, we're not going to get very far today, I think, with them. We'll have a low number. Our high was yesterday. I think it was 13, was it not? I don't think we'll beat it. Karen Reed left the sidebar early. Now she's going back to it. Mm-hmm. I will say, I think a lot of the court demeanor is been after the judge chastised both sides, in a private. Then she was chastised by the defense for making them look bad by being ornery with them in public in front of the jury, which she should never do. She knows. She immediately apologized to the jury for it. Said that she should never act that way. Everybody was being tense. The lawyers do have disagreements, but they're all going to do better. And then today we see they are all doing better. So I don't know if it was because, she actually talked to the lawyers, or which she did, but they actually brought it to light that she was doing similar, because she came right out and said it was brought to her attention, and she apologized to the jury that it shouldn't happen. And she was going to do better. They were all being very tense. You remember that one hearing was horrible. They were all like it was like a cat fight.
Jurors, every piece of evidence that you're getting is recorded, and we have to keep a very clear record. So sometimes we spend time that may seem like a waste of time to you, but it's very, very important for the case. So we do appreciate your patience. All right, go ahead, Mr. Brennan.
Thank you. Trooper Bukhenik, you shared with us that you met with some of the members of the state police that night and then returned to the Norfolk County District Attorney's Office to put the clothing on butcher paper, you called it. What was your next step in your investigation?
We met and discussed the next steps. My decision was to go back to 34 Fairview and excavate for the missing clothing item, being Mr. O'Keefe's hat. There was also plans to start writing search warrants.
Did the weather get better over the next couple days?
The weather did take a turn for the warmer temperatures. Yes.
Did you return to Fairview a few days later on February 3rd?
Yes, I did.
Was that the first time you personally had visited 34 Fairview?
Yes, it was.
When you went to 34 Fairview on February 3rd, 2022, do you remember about what time in the morning you went?
Sometime between 8:30, 9 o'clock, maybe 9:30.
When you went there, did you travel with anybody?
Yes.
Who did you travel with?
It was other members of my unit and a member from crime scene services.
Did you all travel in the same vehicle? Or did you meet there?
We all traveled in our own issued cruisers.
Was this a planned search or a planned excavation on February 3rd,
Yes, it was.
2022?
Yes, it was.
Who was there at the scene, 34 Fairview, with you?
It was Trooper DeChico, Mike Proctor, and Trooper Evan Brent.
And Trooper Evan, last name?
Brent.
Brent. Was Trooper Brent the photographer?
Yes.
What type of tools did you bring when you went to 34 Fairview?
We brought snow shovels, garden shovels. I brought a like an e-tool, military style e-tool.
Was there still some snow on the ground?
There was, yes.
Did you and the members of the group begin to look for any evidence?
Yes, we did.
Were you looking on the street or did you move to more on the grass?
Objection, Your Honor.
Ask it differently.
What area were you focused on at this point?
We were focused on the lawn portion of the property by in the vicinity of the flagpole, the fire hydrant, and along the edge of the asphalt.
Did you see a berm, an asphalt berm separating the concrete street and the yard?
Yes,
Were you looking anywhere near the area of the berm?
we did, yes.
Were you looking anywhere on the street?
The street was plowed, but portions of the street still had remnants of snow, so we did check that area, but it was much easier to identify anything because it was clear of snow.
Where was most of your focus?
On the lawn.
As you worked your way through the lawn, did you or members of your team come across any items that you believe to be evidence?
Yes.
I'm going to ask you to produce some of that evidence to us. Beginning with 535, did you find a number of pieces of plastic?
Yes.
Could you produce 535?
Yes, sir.
Let me just ask you a couple questions before you open that. If somebody identified an object that they believe to be evidence, what was the process to handling it?
On this day, we identified an evidence. The process would have been documenting each item that was located with photographs. Then one of the members of the individuals present would bag each item into a paper bag.
When they were bagged, would the person bagging them use any type of protection like you're using?
Absolutely, every time.
After the items were bagged, was the bag sealed?
Eventually it was sealed, yes.
When you say eventually, what does that mean?
Once it was, all the items were inside and it was brought back to the office, it would be sealed, signed, completely filled out with all the pertinent information on the back.
Could you open that bag?
Yes, sir.
before you take the pieces out, I'm asking you to look in. Do you recognize those pieces?
Yes, I do.
What do you recognize them to be?
I recognize them to be the items that we recovered from the lawn area on the left side of 34 Fairview Road on February 3rd, 2022, during the planned excavation of the property.
And were they photographed before they were put in that bag?
They were.
Your Honor, may I approach before Trooper Bukhenik
Yes.
opens that bag or goes through it?
Did you show Mr. Jackson?
Hand you a series of photographs. I'd ask you to take a look at them, see if you recognize them.
I do recognize them.
And what is in those photographs?
The photographs depict items collected from the lawn at 34 Fairview on February 3rd, 2022.
Do those particular photographs correspond with the pieces of items that are in that bag?
They do.
I have moved this series of photographs in evidence.
No objection, Your Honor.
We'll mark them separately, please.
Thank you very much. Those items, were they eventually sent for analysis to a Massachusetts State Police lab?
Yes, they were.
When the laboratory received those items, are you familiar whether they marked them with a label or a number for identification?
No objection, Your Honor.
I'm gonna allow that.
Yes, they mark each item individually.
Do those items have markings on them reflected by an item number?
Yes, they are.
When you refer to a piece, will you refer to that item number that is on any individual piece?
Once it's labeled, it is identified by that individual piece, by that designated label.
So if there's any numbers written on any of those pieces, was that written by you?
No.
Would that have been written by somebody else after it was sent?
Yes, at the lab.
Okay. If we can begin, if you can begin to take the pieces out so we can show them to the jury. And does that have a number on it or a tag?
Yes, it does. This is item 22-02-184-7-8, also alphanumeric A.
May I approach, Your Honor?
Yes.
Thank you.
These two are taped together.
When you found them, were they taped together?
No. They're taped together by the lab. There's also a canister labeled debris collection. That number is 22-02184-7-8.1. This is 7-8G. This is 7-8N as in November. There are also items too small to label with a letter and number. Those were put into a bag like this. Almost looks like a stamp bag, wax stamp bag.
Are those all the items in that bag?
Altogether, there are, it does look like those are all the items. Some of them are inside the canister that I pulled up.
Understood. You want to move those items into evidence, please? Sir, you mentioned that there was a trooper there photographing the evidence.
Yes, sir.
Did the photographer take a photograph of the items in place when they were found, or were the items moved to a different location before they were photographed?
That day, every item was photographed where it was found.
With the court's permission, I'd like to show a number of exhibits to the jury.
Okay.
Starting with Exhibit 89, which is P490-7690. Trooper, is that one of the items you found that morning?
Yes, it is.
Do you know where, in relation to the fire hydrant or the flagpole, this item was recovered?
It was in the general vicinity between the flagpole and the fire hydrant. The area we were excavating was approximately 40 to 50 square feet in area.
Mr. Brennan, can that be expanded, please, so that the jurors can see what you're looking at?
Thank you, Your Honor. Is the item that you recovered on top of that leaf?
Yes, it is.
Thank you. If I could next show Exhibit 90, which is P492-7692. Before we close up, sir, is that the fire hydrant that is at the corner of 34 Fairview Road?
Yes, it is.
Could we close up, please, on that? Why is there a ruler on the ground?
The ruler is utilized to help put the item to scale by the photographer from Crime Scene Services. They utilize these measuring rulers for scale of the item that you're looking at. Sometimes it's hard to depict how large an item is if there's no reference point.
Could we do a little bit further view to show the fire hydrant? Thank you. Is that where this piece of evidence was found, in that exact location?
Yes, sir.
Thank you. I'd like next to show to the jury Exhibit 91, which is P515-7721. Do you recognize that piece of evidence?
Yes, sir.
Could we zoom in, please? Is that the same piece of evidence that is depicted in Exhibit 89, P490-7690, a different angle with the ruler?
Yes, sir.
Thank you. If we could have Exhibit 92, please, which is P493 7694. Could you zoom in, please? Is that piece of evidence in the bag that you've provided as evidence, physical evidence?
Yes, sir.
Was this found near the area of the other pieces?
Yes, it was.
If we could show Exhibit 93, P507 7711, please. Could you zoom in, please? How long did you spend that day looking, you and the team, for pieces of evidence?
I was probably 45 to an hour.
And finally, if I could show Exhibit 94, P503 7707. And could you zoom in, please? And this piece of evidence, where in relation to the other pieces was this found?
In the same vicinity.
Thank you. If you could take that down, please. When you were searching, did you find any item near the street area?
Yes, we did.
What did you find?
A black plastic drinking straw.
Could you retrieve 536 for us, please? I've moved this piece of evidence into evidence.
No objection.
All right.
May I approach, Your Honor?
Yes, let's get it marked.
I'm sorry, Your Honor?
Let's wait till it's marked.
From the photograph, do you recognize that, sir?
Yes, I did.
What's it a photograph of?
It's a photograph of the black drinking straw that we found at 34 Fairview on February 3rd, 2022.
What location did you find it in?
It was close to the paved berm on the street.
This is after the street was plowed.
Yes, it was.
I think this is evidence as an exhibit, please.
Okay.
No objection.
Exhibit 98.
Yes.
I'd ask you to open this and show it to the jury.
Yes, sir.
With the court's permission, I'd like to show Exhibit 98 to the jury,
Okay.
and that is P4887688. Sir, could you look at that photograph? And Ms. Gilman, could you close? Do you recognize what's in that photograph?
I do.
And what is that?
That is the photograph of the straw we picked up from the street in front of 34 Fairview Road.
Could we zoom out a little bit, please, Ms. Gilman? Is that the area where you or your team recovered that straw?
That is exactly where it was found and recovered from.
That photograph doesn't show much of the grass area. How far is that area from the fire hydrant?
It's probably, with my estimate, 15 feet, maybe 20 from the fire hydrant. It's probably 15 to 20 feet if I had to estimate.
Thank you. You mentioned that one of the items that you went back to Fairview to try to find was a hat. Why were you specifically looking for a hat?
I had learned that Mr. O'Keefe was wearing a black baseball hat the night prior to the incident. So with us recovering the clothing from the hospital and the hat was not part of that pile of clothing, we needed to see where the hat was. That could have been a lead. That could be a clue of where Mr. O'Keefe was last prior to being discovered.
Did you or the team ultimately find a hat that morning?
Yes.
Could I have you produce 537?
Yes, sir.
All right, move that item into evidence.
No objection.
So this is going to be 96.
Thank you.
Thank you.
With the court's permission, Bukhenik, could you open that and show it to the
Yes.
jury? Was that item photographed?
Yes, it was.
And when that was taken from the scene, was the same method used of using gloves and putting it in a bag?
Yes, it was.
When the item was it photographed in the place that it was found?
Yes, it was.
May I approach, Your Honor?
Yes.
So I'm showing you a series of photographs. If you take a look at it, the first one, do you recognize that photograph?
I do.
What is it?
It's the accumulated snow that was being excavated at the scene where we located Mr. O'Keefe's hat.
And the second photo?
The second photo is a close-up of Mr. O'Keefe's hat, flattened and frozen to the ground with portions of it exposed from underneath the piled up snow.
Third photo?
Third photo is also of the hat once it's been removed, and you can see the thin blue line, American flag on the front of the hat and the Nike swoosh on the brim.
And the fourth photo, please.
And the fourth photograph is also a close-up of the top of the hat with a scale ruler next to it with grass showing from underneath the hat.
I'm going to put these back in the order you identified them. All right, move these four photographs into evidence.
Okay. Any objection?
No objection, Your Honor.
Do you want them as 4 separate or A, B, C?
A through 99D, so marked.
Thank you. With the court's permission, I'd like to show these photographs to the jury.
Yes.
Be- Beginning with 99A, P526-7733, please. Could you close up just a little bit, please? Sir, can you describe what you see here?
Yes, that's the excavation track by one of the members at the scene. You could see the hat frozen flat to the bottom, or on the bottom of the snow, right on top of the grass. It was under approximately 1.5 feet of snow that had accumulated in the area.
We could next show 99B, P527-7735.
This is again, the close-up of the frozen flat hat to the grass at 34 Fairview Road.
Next is 99C, P529-7739, please.
Once pulled out and flipped over, again, this is the same hat belonging to Mr. O'Keefe that was discovered frozen flat to the grass at the scene.
Thank you. You can take that down, please. Did you search the entire front lawn at that time?
No, we did not.
And we can see from those photographs, is there still snow in that yard?
Yes.
As you continued your investigation, did you continue to go back to Fairview over time?
Yes, based on the amount of snow still present and the fact that we were finding pieces of broken taillight and glass at the scene, and items that we did not expect to find, like a cocktail glass straw. I directed my members to go by the scene every day as the temperatures rose. Snow would expose more evidence on the lawn, and with the hopes of finding each and every item that was present.
On February 4th, the next day, 2022, did you receive a call?
Yes, I did.
Not what was said, but who was that call from?
I believe it was,
I don't want you to guess if you don't know. Was the person a member of any group?
yes,
From what group?
it was Canton Police.
As a result of receiving a call from the Canton Police, or someone from the Canton Police on February 4th, 2022, did you go anywhere?
I was already en route to 34 Fairview to conduct a directed check of the area.
When you say a directed check, you drive by every day on your way to work?
I told my members on every day to work and home to make sure someone's checking the lawn to make sure that any evidence that exposes itself through the melting snow would be identified and collected.
As you were on your way there, you received a call from someone from the Canton Police?
Yes,
Did you arrive at 34 Fairview on February 4th, 2022?
I did.
When you got there, did you see any more items?
Yes, I did.
How many?
One item a larger in size red taillight piece had revealed itself, and it was collected.
Could you produce 710, please?
Yes, sir.
Is that 710, sir?
7-10, yes, sir.
I'd move that item into evidence, please.
No objection.
With the court's permission, could Trooper Bukhenik open the item and show it to the jury?
Yes.
Thank you. Did anybody photograph that item where it was found?
Yes, there was a photograph taken.
Did you take the photograph?
No, I did not.
How did you receive the photograph?
It was attached to the Canton Police reports that were provided. Canton Police documented that item in place.
May I approach?
Yes.
Showing you two photographs. The first page, you recognize that item?
Yes, I do.
What do you recognize that to be?
That was the item I collected on February 4th at 34 Fairview Road, which I was just showing to the jury.
And the second photograph?
The second photograph is a zoomed out general vicinity photograph of the same item from 34 Fairview Road, the lawn area, approximately 7 feet from the roadway.
I'd like to move these into evidence. A and B. Court's permission.
Any objection, Mr. Johnson?
No objection, Your Honor.
Exhibit 101A and B.
With the court's permission, I'd like to show those photographs to the jury.
Yes.
P46, please. Is that a photograph of the item you just showed the jury, sir?
Yes, it is.
And where was it in relation to the other pieces that you had found on February 3rd?
It was further to the right. If you're looking at at the property. If you have the fire hydrant on your left, it was further to the right, on the right bank of the snow that was melting on the lawn.
Is that on the lawn or on the pavement?
That's on the lawn.
And could we show the close-up, please, P47? Thank you. You could take it down, please. When you recovered those items, did you go through the same protocol of gloves and bags?
Absolutely.
Did you return to 34 Fairview on February 10th?
Yes, I did.
Was the snow in a different state than when you last left it on February 3rd?
Yes, it had receded significantly.
When you went back on February 10th, were you with anybody?
I believe I was with another trooper.
Do you know who that was?
I don't remember. I'd have to refresh my memory.
Was it Michael Proctor?
It might have been, yes.
Could you produce 7-11, please?
Yes, sir.
Does that bag contain some of the items you found on February 10th at Fairview Road?
Yes, it does.
I'd move that into evidence, please.
No objection, Your Honor.
Exhibit 102.
Can you describe generally the size of the items in that bag?
Can I open it?
Please.
Generally speaking, there's 6 plastic pieces of clear and red and black items that are in size approximately to like $50.
Without going through every one of them, can you just pull out one red and one clear to show the jury a representative sample of what's in the bag? In total, there's 6 items in that bag.
In total, there are 6 items in the bag.
When you retrieved those items, did you use the same protocol of gloves in a bag?
Yes.
Did you photograph these items when you took them?
Not on this day, no.
Why not?
We had been to the scene so many times. It was the same general vicinity, and we just made the decision not to have crime scene come out to photograph these six pieces.
Were they in any remarkably different position than the other pieces? Anything that stood out, or were they in the, let me rephrase that. Where were they generally in relation to the other pieces that you had found?
They were all in the general area where the other pieces had been located. It was on the left side of the lawn, but near the flagpole, between the road and the home.
Was there another group of items that you found that day that you put in a separate bag?
Yes.
Could you provide us? May I approach? I'm not sure if I've marked this one for evidence.
Yes.
Or not. Could you produce 7-12, please?
Yes, sir.
I'd move this into evidence, please.
No objection.
With the-
Exhibit 103.
With the court's permission, could Trooper Bukhenik open the bag?
Yes.
In that bag, are there different types of items? The items you showed us before were appear to be plastic.
Yes, these items are packaged in wax paper. There's 14 pieces in total, and these items contain glass and plastic fragments, some of which are also within like a cylindrical tin container that you saw earlier.
Could you show us some of the glass pieces, please?
Yes, sir. I'm going to have to open the wax bag.
Please. Could you stand so the people in the back can see? Thank you. Were there a number of different items inside that are inside that bag that you found that day?
Yes, there are a number of glass pieces taped and labeled for identification at the lab and mechanically pieced together to form this one piece in my right hand. And this is one solid, thick piece of curved glass in my left hand.
And again, is this February 10, 2022?
Yes, it is.
The last evidence bag, you said that you did not photograph where they were found. Did you photograph where these pieces were found?
No, I did not. No.
Any different reason than the last bag?
No.
Do you have a memory of where these items were found in relation to the items in the last bag?
Yes, they were all in the general vicinity where all the other taillight pieces were located, as well as the baseball hat.
How much snow was on the ground at this point?
Most of the snow had melted. There might have been some areas that was still present because of the excavation that took place. So very little to no snow was present at this point in time.
May I approach, Your Honor?
Yes.
Is that all the pieces that you have that you were part of finding or retrieving from 34 Fairview Road related to plastic or glass discovery?
Yes, sir.
Did you continue to work on this case?
Yes, I did.
At some point, did you receive video from a number of different locations?
Yes.
Where were you part of retrieving or receiving video from?
I was part of retrieving and receiving video from CF McCarthy's, the waterfall. There was also video that was collected from other agencies and entities.
Did you seek a search warrant or video evidence from a company called Ring?
Yes.
For what location?
For the Meadows Ave location, Mr. John O'Keefe's residence.
Did you receive video from Ring, directly from Ring?
Ring sent over files with Ring video.
Was that by link, by a computer?
I'm not sure how it came in. It was via the internet.
Did you view all of the files that were produced by Ring?
At some point, I reviewed all the files, yes.
Was that pursuant to a subpoena?
I'm sorry?
Were the Ring videos produced pursuant to a subpoena?
Through the search warrant, yes. We requested it through the search warrant. That's the way that these providers, service providers, respond to court legal service.
Were you aware that some cruisers or the cruisers at the Canton Police Department had dash cam video?
Yes, I am aware of it.
Did you obtain and review video?
Yes, I did.
Have you seen other video from the Canton Police Department?
Yes, I did.
At some point, were you asked if you would consent to provide your DNA?
Yes, I was, yes.
Is that uncommon in investigations?
It's not common, but situations do arise where you're asked to do that. So it's not the first time that's happened, but it has happened before where a law enforcement individual officer has to provide DNA and they consent.
Did you?
Yes, I did.
Did you review any other materials in this case? Did you review any reports?
I did review reports, yes.
Did you write reports in this case?
Yes, I did.
Now, I want to ask you about Michael Proctor. You had told us that you were working on this investigation with him.
Yes, I was.
Are you still working on this investigation with him?
No, I am not.
You were Michael Proctor's supervisor?
Yes, I was.
When you work for the state police, you have a personal phone and a phone that is provided to you by the state police?
Yes.
The state police phone, is that a work phone?
Yes, it is.
What type of information do you receive on that phone?
You can receive communications via email, text message, cell phone tower, voice communications.
Okay. Do officers communicate with each other at times on those work phones?
Yes, they do.
And during that time, did you have a work phone that you were using for communications?
Yes, I did.
At some point, did you receive or were you placed on an email chain that included Michael Proctor and others?
I believe it was a text chain.
I'm sorry, a text chain.
Yes.
Were you included on a text chain involving Michael Proctor and others?
Yes, I was.
Did you receive a text or a text chain from Michael Proctor and other people?
Yes, I did.
And when you received a text, do you remember where you were when you received the text chain?
The specific one you're referring to, I was at the Logan Airport working a traffic detail.
When you received that text or text chain, did you respond?
I acknowledged the text. I did not respond through with verbiage.
And then during that text chain, did you look at the entire text chain?
No, the text message came through on my Apple Watch as I was controlling traffic. I glanced at it. took part of the information that came through and acknowledged it with a thumbs up emoji, indicating that I read it.
At some point, did you learn everything that was on that text chain?
Yes,
And as a result of that text chain, was there an investigation?
there was.
And during that investigation, you were Michael Proctor's supervisor?
I was.
After the investigation was done, did the state police make any finding against you for that text chain?
Yes, there were 2 sustained findings as a result of that investigation.
Did you initiate that text chain?
No, I don't believe so.
You did react with a thumbs up?
I acknowledged the text message that he sent, or portion of the information that came through on my watch.
And the 2 sustained findings against you, were one of them for failure to adequately supervise?
Yes,
And the other, was it regarding a routine or regular review that it didn't consider that text chain? I'll rephrase.
Okay.
That second sustained finding, was it regarding a review of the performance level of Mr. Proctor?
that's correct.
Sustained is to full.
Was there a second sustained finding?
Yes, there was.
Did it relate to the review process of a subordinate?
Sustained is to full.
What was that second sustained finding about?
The accuracy of the review of the quarterly performance evaluation.
You said quarterly. How often would you write reviews for subordinates?
Every 90 days.
Was there any other sustained finding against you?
No,
Was there punishment in light of those 2 sustained findings against you?
there was.
And what was that punishment?
I lost 5 vacation days.
Do you presently work in the homicide division of the Norfolk County District Attorney's Office?
I do.
Are you currently a sergeant?
I am.
Have you ever reviewed that entire chain that was at issue?
Only through the documents provided for me during the internal investigation.
May I approach, Your Honor?
Yes.
May I stand here?
Sure.
So I'm going to ask you to take a look at that document. And if you turn the page, does it begin to, one more page, please. Does it begin to reflect the email chain?
Yes, it does.
Do you remember this email chain?
I remember seeing it when I reviewed it. I don't remember the intricate details of these messages.
Do you remember that photograph?
I don't.
Okay, could you turn the page? Is there text?
Yes, there is.
Without citing the phone numbers, I'd like you to cite the author of the text, and I'd like you to read the text to the jury.
Do you want me to date it in time or no?
Sure.
August 17th, 2022, 9:44 p.m., 25 seconds. Funny, I am going through his retarded client's phone.
I'd like you to read all of them, please.
Next one, no nudes so far. I hate that man. I truly hate him.
Hey, can you give the author for each comment? And can you start again, because I want us to understand.
I'm sorry, can you repeat that?
The author, whoever makes the comment, I'd like to have the name of the author.
I'm sorry, this document does not identify who the author is, sir.
Dan?
Yes.
It identifies this as your phone,
That is, yes.
but each comment doesn't identify who sent it.
No, it does not. I assume it's an extraction from one device, but
I see. If you've made any of the comments yourself, would you tell us?
if I made those comments,
No, if you make any of them in here as you read them, will you point out if you?
absolutely, yes.
Okay. And if you don't know who made the comment, could you just identify that for us as you read it so we know?
Okay, do you want me to continue the next page?
Why don't we start over because I
Okay.
should have been more clear in my direction. Could you begin again?
So in the beginning, it says, funny, I am going through his retarded client's phone.
Is that your comment?
No, it is not.
Okay, next.
It appears to be the same person because of the way that the extraction happens, and it says no nudes so far. Again, this, I believe it's the same person because all of these are identified as sent. It says, I hate that man. I truly hate him.
Do you have any belief that's Michael Proctor who was writing these?
Yes, I believe
Okay.
that is.
Next, please.
There's a blank page, and that's the end. Yes, sir.
Did you say you were suspended 5 days or lost 5 days vacation?
Lost 5 days of vacation.
And have you continued on your cases?
Yes, I have.
I want to go back to the evidence that you reviewed in this case.
Okay.
Did you get to look at the ring video for John O'Keefe's home at Meadows?
Yes, I did.
Did you review the video over a period of time of January 28th and January 29th?
I did.
What were you looking for?
We were looking for activity to get a timeline. During investigations, different sources provide you information that can develop into leads. It also helps verify witness statements. It helps verify information that's coming in. We always trust, but we always verify the information that we take in from individuals we do not know. So although it could be a cooperating witness, you still have to verify that their information is accurate. Not that they might be intentionally misleading you, but 3 people can watch the same event and observe it differently. So it's good to talk to individuals and pick up on different facts that they remember, giving you a whole picture of what took place.
Did you review ring video for January 28, 2022 and January 29, 2022?
I did.
With the court's permission, I'd like to show a number of segments of the video from January 28, 2022.
Okay, the one that's already in evidence?
It is, it's Exhibit 6.
Okay.
Thank you. When you reviewed the video from the ring that Ring provided for Mr. O'Keefe's home on Meadows for January 28, 2022, did you review it from the morning time at about 7:18:55 throughout the evening?
On the 28th?
Yes.
Yes.
If I could have video 119. Thank you. After that video, did you have an opportunity to look at video at about 5:05 p.m.?
I'm sorry, there was a noise coming from a bag over here. I apologize.
Not a problem.
Can you repeat that question?
Sure. On January 28, 2022, did you have a chance to look at video from the ring at about 5:05 p.m.?
Yes.
Could I have video 145, please? Thank you, Ms. Gilman. There's more video. Did you have a chance to look at video from a little later that evening, 7:36 p.m.?
Yes, I did.
Could we have video 149, please? Thank you. In your investigation, did you learn that the defendant's phone connected to Mr. O'Keefe's Wi-Fi at his house on January 29, 2022 at 12:36:39?
Yes.
Did you look for any ring video for that time, 12:36:39?
Yes.
Was there any ring video on the production that was sent to you by Ring for the time period of around 12:36:39 on the evening of January 29, 2022?
There was no ring video for that time frame.
Did you look for ring video around 5:07:58 that morning on January 29, 2022?
Yes, I did.
Could we see video 153, please? Thank you. Did you review that video from 5:07:58?
Yes.
Did you later review video of 5:46:29?
Yes.
Could we play number 154, please? Could you stop that, please? Do you recognize what's in that video?
Yes, I do.
What is that?
That is top left corner is Mr. John O'Keefe's vehicle. Middle left side of the screen is a black Lexus SUV registered to Karen Reed with the license plate based on that registration. And then on the right side, I believe that's Miss Carrie Roberts' vehicle.
Did you see the people enter the house?
Yes.
Did you look for further video after the people arrived at 5:46:29?
Yes.
Was there any video of those three people leaving?
No, there was not.
Was there later video at 7:05:16 a.m.?
There was, yes.
Ms. Gilman, can we see video 155, please? Thank you. Did you later see video at 8:23 a.m.?
Yes.
Can we have exhibit or video 159, please? Thank you. Did you later see video at 10:36:28?
Yes, I did.
Could we have video 161, please? Could you stop that, please? Do you know who's in that video?
I believe it's Mr. Paul O'Keefe and Mrs. O'Keefe.
Could you please play? Okay, thank you. Did you later look at video of 12:04?
Yes.
And could we please play the 1-minute segment of video 165? Could you stop that video? Do you know who that is?
I believe that's the defendant.
Continue, please. Could you stop that? Do you know who exited the car?
I believe that's Mr. Reed.
Okay, continue, please. Thank you. Did you continue to watch the video from the driveway
Yes.
during that time period?
Yes.
Did you see anybody else get out of that car that was in the back?
Yes.
And who did you believe you saw getting out of that car?
I believe it was the defendant's brother and possibly his companion. I don't know who that is.
Did you have a chance to watch the video?
Yes, I did.
At 12:35 p.m., could you play video 174, please? Thank you. Did you look at video from 12:40?
Yes, I did.
Could we have video 171? and 175. Thank you. Did you look for further video to see if there was any video for the time around when the Lexus was taken from Meadows that morning?
Yes.
Was there any video that was produced that shows the time around before and the time that Lexus was removed from that driveway that morning?
There was no video, no.
When you were at the Sallyport, did you get an opportunity to look at the Lexus's rear taillight area?
Yes, I did.
Did you get to make observations about the damage that you viewed that morning?
Yes, I was.
Did you later have a chance to see, after the snow melted, what that damage looked like?
Yes, I did.
Could I have Exhibit 54, please? Do you recognize what's in that photo?
Yes, I do.
And what do you recognize it to be?
That is the defendant's Lexus SUV that was seized and later processed. It's currently in the Canton Sallyport, I believe.
Could we close up on the right rear taillight, please? Do you notice anything about that right rear taillight?
Yes.
What do you notice?
It's missing a large red portion of the lens.
Is that consistent or inconsistent with the damage that you saw when you first saw that car?
That is 100% consistent.
Did you get an opportunity to see any video or photographs of that right rear taillight before the car was placed in the Sallyport video?
Yes.
Did you view the ring video from Mr. O'Keefe's Meadows Ave address?
Yes.
If we could go back to video 153 from Exhibit 6. If you could play this, please. Did you have a chance to review this video?
Yes.
Is this at 5:07:58 a.m. on January 29, 2000?
Yes, it is.
You stop, please. Do you notice anything about the right rear taillight in that video?
Yes.
What do you notice?
It's showing white and is missing the red taillight cover lens.
Could you zoom back out for a second, please? Could you continue? And I'm going to ask you to stop in a second. Stop, please. Do you notice anything about that still of that video?
Yes, it's consistent with its appearance of missing that red taillight lens.
If you could play the vehicle leaving the driveway, please. Thank you. May I approach, Your Honor?
Yes.
Handing you a document, sir? Do you recognize what's in that?
Yes, I do.
What is it?
It's a still frame from the ring footage taken of the video we just watched of the Lexus SUV leaving, and the large red portion of the rear taillight is missing.
I'd like to move this into evidence.
Okay, any objections to Jackson?
No, Your Honor.
If I may correct the record, the ring video exhibits are from 12A, not Exhibit 6.
Okay.
At some point later that afternoon, you shared, or mid-afternoon, you went to Dighton, but before that, did you review any other evidence of the damage to that taillight before you and Mr. Proctor even got to the Dighton address?
Yes.
Could I have Exhibit 10, please? Did you have a chance to view still photos from the wellness check that was conducted by the Canton Police Department and videos on the dash cam?
Yes, I did.
Did you review this photograph?
Yes, I did.
And could we show a close-up on Exhibit 11? Did you have a chance to view the dash cam from this footage at 8:26:31 a.m. relative to the damage to that right rear taillight?
Yes, I did.
You shared with us that, you can take that down, please. You shared with us that after this time, somewhere around 3:15, you went to Dighton
Yes.
and you shared your observations when you got out of your truck and walked towards the car.
Yes.
Was there any difference between the damages that you've seen in the video, the photograph, and what you saw that morning?
The only difference is the amount of snow that's impacted on the vehicle. The damage is consistent. The large red lens is missing in every single piece of every single image that I saw.
You mentioned that there was a tow of that car in Dighton that you were there for.
Yes.
Were you aware that video footage was provided to us from that tow?
I was made aware, yes.
I'd like to enter into evidence a video from alarm.com.
No objection, Your Honor.
Exhibit 105.
Did you view the video that was provided to us relative to the right rear taillight?
From alarm.com?
Yes.
Yes.
Court's permission, I'd like to play that for the jury.
Okay.
May I have a moment, Your Honor?
Yes.
This is video 1, Your Honor.
Okay.
Could you play video 2, please? Could you stop, please? Do you notice anything about the color of the right rear tail light?
Yes, it was white.
Could you continue, please? Thank you. You can put the lights on, please. Sir, did you have an opportunity to review video from CF McCarthy's on the evening of January 28th, 2022?
Yes, I did.
Did you have an opportunity to review videos from the Waterfall Bar on January 28th, 2002?
Yes, I did.
Did I say January 20th, January 29th, 2022?
Yes.
Did you review all the entire relevant time periods?
Yes, I did.
When you reviewed those videos, were there a number of different things you were looking for?
Yes, there was.
Can you share with the jury what you were looking for?
We were looking for consistency in statements that were already received through interviews. We were looking for description of clothing individuals were wearing at the bar, at those locations. We were looking for any evidence of aggressive behavior, any sort of information we could learn to help us with the investigation. We're also looking to see and document how much alcohol consumption was on the recordings.
When you went through the videos, did you happen to have an opportunity to copy and clip portions of relevant time frames regarding alcohol ingestion?
Yes.
Did you put all of those videos together in a sequence to show the course of the night, times when you could identify alcohol ingestion?
Yes, I did.
Did you put that into a video format for a presentation?
Yes, we did.
I think this presentation may take a few minutes.
All right, we'll raise the council side off for just a second, please. Jurors, feel free to stand.
This is a very important witness for the Commonwealth. Also, a target witness for the defense. I would imagine we will spend most of the afternoon in cross, if not through tomorrow morning. I would imagine they've got a lot to go through. But I do like Hank Brennan's style. He is meticulously confirming the timeline, confirming the investigation, taking it on the chin with the Proctor problem, kind of diffusing some of it by laying it out in front of the jury in such an honest way on what happened and what was gonna, that this particular witness was also reprimanded just because they were on the chain. They never responded, but because he was his supervisor, he had to take some responsibility for not reprimanding him at the time. Is clip montage on anyone's bingo card? That's something we should consider. Well, thank you, Mandy, for helping me find out what the children testified to in the last one. It was all about the relationship. But now that the ring cam, when I say the ring cam records person, that is someone on the witness list that is from Ring, that is in charge of data of recording.
Yes.
So I wonder if the deletions are going to come in.
CD, do you recognize that?
Yes, I do.
What is it?
It is the PowerPoint presentation of the timeline from CF McCarthy's in Waterfall from January 28th, 2022.
I move this into evidence as an exhibit.
Mr. Jackson has no objection?
There's no objection on that.
Exhibit 106.
Yes, I do.
What are they?
There's still frames from C.F. McCarthy's on January 28, 2022 at 9:26:01 as timestamped on the footage cam.
Are there 4 photographs?
There are.
I move these 4 photographs into evidence.
No objection, Your Honor.
Thank you. Is one exhibit again with the letters, please?
So I'm showing you 4 more photographs. You take a look. You recognize.
Yes, I do.
And what are they?
They're still shot photos of the waterfall surveillance footage from the night of 28th into the morning of 29th.
All right, move these 4 photographs into evidence.
No objection, Your Honor.
It's 108A through 108.
Thank you. Your Honor, could I proceed with the PowerPoint presentation?
Yes.
Trooper, I may stop you at a couple points.
Yes, sir.
Could you explain to us what this is?
Yes, from left to right, it is chronological events that took place at C.F. McCarthy's. This is surveillance video from one of their cameras within the bar. It should be noted that the video is time-stamped 12 minutes behind actual time. So when it says 9:03, when it is 9:03, the frame will be timestamped 2051, which is 8:51. So that's the time discrepancy, which is consistent throughout the surveillance footage.
So the times that are displayed in those arrows, is that the accurate time?
The arrows are the accurate time, and the time stamped 12 minutes behind actual time.
In these videos, are you identifying drinks that were received and had been consumed by the defendant?
Yes. So the first video, as it is labeled, it's the defendant arriving. The next one will be the ordering of the drink and receiving the actual cocktail.
Okay, let's start with the first video at 9:03, please. Could you stop it there? Do you recognize who's in that video?
Yes.
From left to right of people that you recognize and identify the clothing they might be wearing?
From left to right, it'll be Mr. John O'Keefe wearing the gray sweatshirt that was displayed earlier. And then the defendant, who he is trying to embrace with one arm there. I do not know who the other individuals are in the shot.
Okay, thank you. If you could continue, please. We could proceed to 9:10. What did that show, sir?
It showed the defendant receiving her first tall vase, cylindrical style cocktail glass with a lime in it and a straw to go along with it.
927, please. And what was depicted in that video that you saw?
In that video, we see the defendant get handed her second cylindrical tall style cocktail glass while she finished the first one and then picked up the second one.
When you've made a relevant observation in the video, please interject and stop so you can point out for us what you've seen.
Absolutely, sir.
Okay. Next, please, 932.
Here, the defendant is handed a shot.
Stop, please. Okay.
Right there.
I think we'll just have to play it and you'll have to speak as you're watching it. It doesn't look
Okay.
like it can be stopped. Sorry, Ms. Gilman.
She's handed a shot by the bartender on the left side of the screen. She picks it up and puts it into her second cocktail glass, making it a third beverage of alcohol content that she's consuming. So right there, we observed Mr. O'Keefe retrieve his phone from his rear left jean pocket, and he put it back. Now the defendant picks up her second cocktail glass with the added shot in it and consumes it.
Could we proceed to the next video, please? This is now 9:45 p.m.
Yes, sir. So the bartender hands over another cocktail glass and some beers. The shot goes into the empty one after it's poured into the new cocktail glass. So that's drink number 4.
Does it also depict Mr. O'Keefe putting his cell phone in his back pocket again?
Yes.
By 9:45, how many drinks have been served to the defendant?
4 drinks.
4 drinks between 9:10 and 9:45.
That's correct. In 35 minutes, 4 drinks.
Could we proceed to the next screen, please? 10:09 p.m.
Here the defendant speaks with the bartender and gestures that she wants a shot.
Objection.
The objection sustained.
Move to strike.
I'll strike that.
Mr. O'Keefe on his cell phone again?
Yes, he is. And he puts it in his back pocket. The defendant is showing Mr. O'Keefe the middle finger, and then puts beverages on the bar.
Should I proceed, Your Honor?
Yes.
What is the drink count at that point?
At that point, it's 4 drinks.
Could we have the next?
Mr. O'Keefe brings over a couple of beverages. The defendant retrieves the cocktail glass. A shot glass is picked up by one of the patrons, and the defendant retrieves it from him and places it back on the bar. The defendant is consuming the beverage in her hand, places it on the bar. And then
What time are we at now?
that was 10:34, so we're moving to 10:37.
What is the drink count at 10:34?
That is 5 drinks at that point.
Could we play 10:37, please?
The bartender makes 4 shots, top left corner. She's seen preparing the 4 shot glasses. 2 are on the bar top now. She retrieves 2 more.
$10.41, please.
Here, the 4 shot glasses are redistributed. Pours it into her drink. She does not consume it from the shot glass.
Your Honor, objects last night.
Okay, I'll strike that.
Next video, please.
Now, as the Mr. O'Keefe and the defendant are getting ready to leave, the defendant is holding the drink in her left hand, continues to sip on it. And the two walk out of the bar without the beverage in their hand being deposited anywhere.
At 10:53, how many drinks have been served to the defendant at this point?
7.
Objection, Your Honor.
I'm going to sustain the objection.
Move to strike.
I'll strike.
Next slide. And is
So
this,
I'm going to actually see counsel's evidence on this.
Yeah, I think sidebar is about, like, we're already over lunch. How much longer is this going to be? Let's get this going. And they do not want it stated by anyone who can't actually witness the amount of drinks she consumed, how much she consumed. Like, they have to leave it up to the jury whether she drank those or not, right? Like, it's quite evident from the video.
Lunch and break, it's 1:10. We'll see you at 2 o'clock. And
Okay.
Yes, Your
All
Honor.
rise for the court, please.
I kind of figured we were going to lunch. Why sustain it? Because it's more prejudicial than probative. And he's watching it like through the video, and the jury can make the same conclusion. He's not an expert on it. He didn't witness it, yada, yada. They got plenty of reasons that they can. We saw 7 drinks served. He did not say consumed. I see that. I know that. And he is being asked to say what he sees on the video, and he did compile the evidence. Well, you know, the defense is going to keep objecting. Unfortunately, we don't get to hear the legal objection. I will do a little bit of research afterwards, Liam, but I do believe it's going to be prejudicial versus probative to character, which we can't really do. It could also be in redundancy because it keeps getting stated. Who knows? I'm just, throwing it out there now. So on that, let me just walk this. Okay. Let me get the next video, the next stream up for you and post the link. And we could all use this hour break. They said they'd be back, at 2, I do believe. But I will watch the feed and make sure that I come back before they go up. Here is the link to the next stream. I hope some of you can come keep me company this afternoon. I would definitely take a good break and buckle up because once Hank Brennan finishes his direct, I do believe we're going to have quite the extensive cross. This witness has put a lot to the timeline, has put a lot to the evidence, has really punched some holes in what the defense intends to lay out there. So I would imagine it's going to be an aggressive cross to try to take back some of the damaging information that's been put in front of the jury. And, you know, that's standard. That's their job. But at least we won't be falling asleep this afternoon. Yeah, she was, Maggie. It did appear like that to me too. You know, and she has said in her interviews about the drinks not being strong enough, so they bought extra shots, so she put it in, and yada yada. Like, she does talk a bit about it. She talks about maybe she had up to 9 that night. There are receipts that are going to come in from the bars, I believe they did in the first trial. So that's why I can understand why Liam is confused as to why it was sustained as to the amount of drinks, since it could be seen on the video. Is there an objection for assumption? I don't know. And she did take it out, which kind of lead, you know, because of the glass that they found at the scene. Testimony that she said he took her drink in one of the interviews from the car or the vehicle that they were in. Well, anyway, we could talk about all of this later in this while we're waiting for them to come back on the next stream. Well, for now, I'm going to call it and go get a good stretch myself. Thank you all for keeping me company. Don't forget to like, share, and comment. If you come up with anything else that you would like researched or any other questions in regards to this case or any other case I'm following, please hit the comment section. I check them all, and I'd be glad to look things up and have a discussion with you. So I'll see you all in about an hour. Say goodbye, fan. Bye, fan. We'll see you soon.